All persons having anything before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone. This is Monday, May 12th sitting. Our panel today is myself, Sabita Singh. To my right is Justice Andy D'Angelo. To my left is Justice Chris Hodgins. So let's get right started with the first case, City of Somerville versus Sean Williams, 24P 398. Will counsel please introduce himself?
May it please the Court, good morning, Your Honors. My name is David Shapiro for the City of Somerville. There are two major key points we have in this case. One, there is a privacy interest in resident parking permits that are required to be obtained by residents in Somerville. And my second major point is that the public interest does not substantially outweigh the privacy interest in disclosure. As to the privacy interest, there are two separate arguments. I think that's really important for the Court to note. The first argument and the primary argument is that the Court must recognize a privacy interest to meet the reasonable expectations of privacy of residents in Somerville. The second key point on the privacy interest is that the Court must recognize a privacy interest to avoid standing as an obstacle to the Driver's Privacy Protection Act. I do want to focus today primarily on the first point, but I think the first point renders the second point not necessary to even reach. Once again, is there a reasonable expectation of privacy?
Names and addresses are not inherently private, either, are they, under the case law?
They are not intimate details of a personal nature. However, the Court has ruled that whether something is an intimate detail of personal nature is not dispositive. That's in the Boston Globe case, and it's also been recognized by the United States Supreme Court in some of the later cases. There was a prior case, 1980, which recognized that in order to use Exemption C, you must have an intimate detail of personal nature. That was 1980. 1982, the United States Supreme Court ruled that under a comparable exemption, you don't need to have an intimate detail of personal nature. Therefore, you are left with the conceptual informational privacy interest, which is the issue before this Court.
I guess that's where I don't understand. So in this case, if the information is disclosed, it would disclose the names and addresses of the people who have the parking permits, correct?
That's correct.
So why was it wrong for the judge to say there was no privacy interest because she said it's only disclosing the names and addresses, and I don't find that to be a valid privacy interest? What's wrong with her saying that?
Sure, because under the Driver Privacy Protection Act, there are two key purposes. One purpose is to protect the privacy of residents, and under that federal law, names and addresses are withholdable.
You agree, though, that the DPPA is not really forceful as far as the law goes for this case, correct? It might have guidance, but it's not the law of this case.
Exactly correct. We look to the DPPA for guidance. The federal law is clear that if we had turned over these documents, there would be no violation of the Driver's Privacy Protection Act. That is correct. But we need to look to the Driver's Privacy Protection Act for guidance. And that is our point, to look to it for guidance to determine whether there's a privacy interest. Under the Giorgio case, it is a case-specific factor to be looked at for privacy. To align with those goals of the Driver's Privacy Protection Act, a privacy interest must be recognized in this case. If a requester goes to the State Registry of Motor Vehicles and says to the Registry of Motor Vehicles, I'd like the names and addresses of all drivers in the state, there is a privacy interest in that under the federal Driver's Privacy Protection Act, and I would expect they would not turn it over. If the requester went down the street to the City of Boston City Hall, for example, or to Somerville City Hall, and asked for the same information, which is inextricably linked to driving, the supervisor says there's no privacy interest at all. Does that make sense that there is no reasonable privacy interest at all in this case for residents? What are the reasonable expectations of residents? So as to the privacy interest,
Well, what if we just put that aside for a second? What if we were to agree with you that there is some level of privacy involved in names and addresses and so forth? Why isn't this case like the Attorney General versus Collector of Lynn case, where there's some privacy interest in people's names on the tax rolls, but the public interest outweighs that privacy interest in determining who's been paying their taxes?
the public interest would substantially outweigh the privacy interest for a determination as to who's paying the taxes to see who it is who's a tax delinquent. That would be different in this case. What is the public interest in knowing who it is, who were the drivers in Somerville, other than potentially what they said in Boston, what they determined in Boston was they turned it over. And there is a bare allegation, I believe, at its best, that the records are reflecting improper conduct or errors by the city. There's no evidence of that, and that brings us to
Yes, but how do you know until you get the records to look at them, right? So in other words, there is a public interest involved here, and it's making sure that the city is properly administering this program, and it's giving parking permits to people who merit getting parking permits, and there's no preferential treatment involved.
That's correct, Your Honor. There isn't public interest in that, but under the Massachusetts Landlords Incorporated case, where Your Honor was actually on the panel, versus Executive Office of Housing and Livable Communities, when that is the basis of the public interest. Bare allegations do not suffice. Speculation does not suffice. We turn back to the Boston Globe Media Partners case, where the public interest being asserted is to show that responsible officials acted negligently or otherwise improperly in the performance of their duties. You need more than a bare suspicion. You've got to show that evidence that warrant a reasonable belief that the alleged government impropriety might have occurred. So the privacy interest, once again, is implicated because of the looking to the DPPA for guidance, for instruction. Intimate details, not dispositive. I understand that names and addresses generally not dispositive. You need to look at it in context. And I think that example I gave shows why there is a reasonable expectation of privacy for residents. Other source availability does not apply here because of specific information in the public domain must duplicate that database. This is not a voting database. This is a driver's database, not the same database. As far as public interest.
It's not a driver's database. The driver's database comes from the Registry of Motor Vehicles, which is governed by the DPPA. Here, what the city was providing was people with parking permits. So isn't there a difference between driver's information at the registry versus parking permits at the city?
In this case, the parking is inextricably linked with driving. A person who goes to the registry wants all the drivers. Database, they don't turn it over. Now you come over to City Hall in Somerville, and you say, you know you can't get the driver database from the state. It just so happens that Somerville is a large city, densely populated. We have a parking permit program. Or, for example, let's use Boston as an example, even a larger city. You can basically do an end around the state law and the federal protections in order to get that information that is privacy. Informational privacy, I can say over the last 10 years, has become very big in communities.
But don't you see that the registry information is, I'll say, over-inclusive because it gives out information, it could give out information other than the DPPA of every driver in the state of the Commonwealth of Massachusetts. Whereas in Somerville, they're not asking for all drivers of Somerville. I don't even know if that information exists at the city. They're saying we just want the limited portion of people who have parking permits. So it's limiting what they would get from the registry to a subset, isn't it?
It's a subset, but there is still a reasonable expectation of residents in Somerville, and that's what we look to. What is the reasonable expectation of those residents? And the expectation
is there any law or case that you could point to that suggests that somebody can't get all the residents of Somerville, their names and addresses?
They could get that, for example, from the census or from the voter database. But here, once again, in order to be otherwise available, the case law, Afshar versus United States Department of State, it has to be that same database. Otherwise,
I'm sorry, you lost me. So it's permissible to get every resident in Somerville, okay? I want the names and addresses of all the residents of Somerville. But it's not permissible to get even a further subset of that, of the names and addresses of everyone who has a parking permit. How do you make that jive with your argument?
Because the federal law carved out something. Normally, there is no privacy interest, for example, in building permit applications. That's different. We have a federal law that gives us instructions, and it tells us that there is an expectation that people can drive in privacy. Now, we know why this federal law happened. It was based upon someone who was murdered back in the 90s. So they passed a federal law they carved out for drivers. Why did they not pick voters? I don't know. Why did they not pick other subsets? I don't know. The federal law carved out this specific exception, if you will, where they gave us instructions on what to do. And it's our responsibility to safeguard that as a city, to safeguard that information that we have in our possession that relates to individual drivers. I do want to mention on the public interest component, the burden of proof is on the supervisor to show that the public interest substantially outweighs the privacy interest. There is a mention in the brief of Mr. Kerrigan that balancing test is not a substantially outweighed balancing test. It is substantially outweighed. And once again, to my key point, if you're alleging impropriety, or you're alleging favoritism or some kind of error in the city records, it isn't enough to just do a bare allegation or suspicion or to just say that there's a public interest. It has to be evidence.
But see, that strikes me as not logical. If the public record law is designed for sunshine, that records of the public are supposed to be available to members of the public, why does there have to be some allegation of wrongdoing in order to effectuate that right of access? That doesn't seem to make sense. And I go back to this case, the Attorney General versus Collector of Lynn, which we're bound to follow. And in that case, the action arises out of a request by individual members of Lynn Fair Share to the Collector of Lynn for lists of owners of real property in Lynn who were delinquent in the payment of their real estate taxes. There did not have to be any allegation of wrongdoing. It could be idle curiosity, couldn't it?
No, Your Honor. That's under the NARA v. Fabrish, United States Supreme Court, 541 U.S. 157, as well as the Mass Landlords case versus Executive Office of Housing and Livable Communities. Those are perhaps later cases. And in fact, and this goes to the issue of building permits, for example. Building permits, it would make sense to make those publicly accessible so people can look out for noise or impacts on the community. In the issue of tax delinquents, there's a public interest in knowing who it is who's not paying their taxes. That's an entirely different question of whether someone is driving in privacy, especially in the context of that federal law. And I do want to mention one thing. Normally,
But the public interest is in what the government is doing, right? It's not necessarily what the people with permits are doing, but it's what the government is doing. Isn't that the public interest there?
right, there's a public interest in overseeing what the government is doing. However, when you are alleging favoritism or wrongful conduct or anything of that nature, you have to have a showing under the case law. And if a totally unsupported allegation, there's also, I want to do quote this case from the United States Supreme Court, if totally unsupported suggestion that the interest in finding out whether government agents have been telling the truth justified disclosure of private materials, government agencies would have no defense against requests for production of private information. Once again, there needs to be a public interest that substantially outweighs the privacy interest. Tax delinquents is an entirely different matter, as would, for example, building permits, in terms of that public interest balance, because there is an interest in knowing that, for example, individuals are not paying their taxes. That's a different concept than in this case what we have is a purely private matter that's completely attenuated to government activity. This is asking for a database of residents. That's what it's essentially asking for. And that is entirely different than
it's
a
asking
database.
for a database of a subset of residents, of people, only people who have parking permits.
Right. And that subset, once again, under the federal law and the federal guidance, has a privacy interest. I see my time has expired, so unless there's additional questions, I will rest in my brief.
Thank you.
Thank you.
May it please the Court. Good morning, members of the panel. My name is Michael Kerrigan. I practice at Sloan & Walsh in Boston, and I'm here today as a Special Assistant Attorney General with the privilege of representing the Supervisor of Public Records. Your Honors, if I may give you a very brief outline of where I intend to go in the brief time we have here today. What I'd like to do is start with our points of agreement, general propositions of law, transition to some of the concerns raised by the City of Somerville with respect to the DPPA and how it has been properly weighed and considered to the extent it even needs to be considered, both by the supervisor and by the motion judge, and then to look briefly at the very nuanced and detailed analyses that both the supervisor and the motion judge undertook when it came to, one, establishing whether or not there is a privacy interest in the information at issue, and two, whether or not the public interest in accessing that information substantially outweighs the privacy interest in the information.
Let me just tell you what bothers me about this. You know, the people who are designated to respond to public record requests are often not lawyers, and they receive a lot of these, and they need kind of a quick way of determining whether something is exempt or it's not exempt. And so when you look at the statute and it says what is exempt is materials that constitute an unwarranted invasion of personal privacy. An unwarranted invasion of personal privacy. And then we have decisions from our appellate courts that say, well, but first there's a balancing test, and then there's a burden shifting. How does that help this poor person who's working in City Hall, who's dealing with a lot of these requests, and makes a good faith determination that this request is going to violate someone's personal privacy?
As a practical matter, Your Honor, I would think that the city and any other keeper of records would have guidelines to assist that clerk, but otherwise they would have recourse to legal opinions. But to answer your question directly from a legal standpoint, that the practical would be that we would expect that there'd be guidelines to govern the clerk or whoever.
But why can't the person who's in charge of this simply look at the statute and say, well, geez, is there a privacy interest involved here? Oh, geez, well, this is giving out people's names and addresses. That sounds kind of private. I probably shouldn't give this out. Why isn't that enough?
The answer, Your Honor, is that the analysis has to be specific and nuanced, and it also has to be flexible and scalable to the particular circumstances at issue. So let's go to the point that Justice D'Angelo raised right out of the gate, and also was picked up on by other justices. The idea that names and addresses are somehow have a privacy interest is not correct. The law has been very clear on that. The only time a name and address in one context can acquire a privacy interest in another context is when it's linked with other information that may be revealing details of a highly intimate nature, et cetera. So in the Georgiou case and in other cases, the Mass DPH case involving the Boston Globe, we have situations where you have names and addresses, again, in and of themselves are not inherently private, but when you link them to, say, a first report of injury that's sent into the workers' comp carrier, as plaintiff's attorneys sought to do in the Georgiou case, that reveals disability status. It reveals application for public benefits, or for private benefits, which is essentially what workers' comp is. If we transition to another example, which would be the DPH case involving the Boston Globe, where we had a database of vital statistics. In that instance, again, names and addresses are not inherently private. There is no privacy interest in names and addresses. When you then combine that with a database that has statutorily protected private information that is updated constantly, that can be revisited again and again and again.
How about adding that by getting these permits, they get not only the name and address, they get the permit number, the issue date, the expiration date, the vehicle model, make and year, and the license plate number? Why doesn't that add to the equation of now it becomes a privacy interest because it's connected to other things?
I'm going to trim the amount of information that you're making available to the public, Your Honor. The reason why I'm going to trim it is because the motion judge did it for us. So at issue for this appeal is simply the following data points: parking permit number, issuance date, expiration date, name and address. The license plate is no longer at issue. The vehicle make, model, and year are no longer at issue. Those were taken off the table by the motion judge. And this brings me back to the point of the DPPA. My brother very frequently in the city emphasized that the DPPA gives guidance here. In actuality, as I see it, Your Honors, the language that's used by the city when it comes to the DPPA is the language of preemption, implied conflict preemption. Now, I know that there's a concession that it's not preemption. The argument for preemption is not being argued, but in effect, it is. When the city says that the purposes and objects of the federal DPPA are being thwarted by the Massachusetts Public Records Act and the privacy analysis in Massachusetts, that is implied conflict preemption, and that's not the case here. But let's also consider, as I break this down, that the DPPA is very adequately accounted for in the analysis, both by the supervisor and by the motion judge. And in fact, by my count, it has been weighed probably 3 times or so in the course of the proceedings.
But the case doesn't turn on that federal statute, right? I mean, because would you agree that people do have a privacy interest of some kind in the fact that they own a vehicle, that they drive that vehicle in a particular city, and that they park that vehicle at a particular location in the city? Isn't there some privacy interest involved in that apart from any federal statute?
There may be, Your Honor, but we're not talking about that. We're only talking about name, address, and a permit.
Yeah, but it implicates, as your brother says, the problem, as the city sees it, is it's implicating other factors, such as that you own a vehicle. Maybe people don't want to have people know they own a vehicle, or that they store it in a particular location, that it's parked at a particular spot that has some designated number. I mean, people kind of want to be left alone, right? Isn't that the nature of privacy?
I take your point, Your Honor, but let me counter you, if I may. There is no case law that suggests that merely owning a vehicle gives you a privacy interest. The privacy interest that my brother is talking about and the city's talking about is specified in a federal statute, which, again, we agree does not apply here. But I cannot identify a case for Your Honor, and I don't think that my brother has either, that indicates that there is a privacy interest in name, address, or parking permit, or just the fact that you have a vehicle which is a public-facing, with a license plate that is public to the world, et cetera, feature of your lifestyle.
Well, the plate is, but not your identity, because the only certain officials are able to access that registration number. So if I'm driving down the street and I have a certain registration plate, I'm not displaying to the world that I'm the owner of this vehicle.
That's correct. That's correct. And neither are we in this case, because again, the motion judge is only allowing to be disclosed publicly name, address, and permit. So the license plate number is not part of the mix in this. So we're just dealing, again, if we go back to the teachings of the case law, again, my brother and I would be hard-pressed to show this panel a case in which name and address are inherently private and even linked with a parking permit that just has dates of issuance and a permit number, which is a randomly assigned number.
What else can you glean from the fact that someone has, from a permit number, Any other information? Will that lead to other information?
Not that I'm aware of, Your Honor. And more importantly, apart from my own awareness, the case law is very clear that when we're doing a privacy analysis and we're arguing about risks of identity fraud, or we're arguing about risks of personal safety, if we're arguing about risks of, say, scammers or, let's say, advertisers targeting individuals, we cannot rely upon speculation. We cannot rely upon hypotheticals. We must be shown, we the court, if I can make myself a judge, we must be shown that there are specific facts that demonstrate a substantial risk in these contexts. And that comes right from the SJC in the DPH case involving the Boston Globe. It's also echoed in the PETA case. And we also have an exemption, separate exemption, not at issue here, exemption N from the Public Records Act that speaks to issues like public safety, risk to infrastructure, things of that nature. So the first point in answer to your question, Your Honor, is that there has to be some specific showing before the court can allow a balancing to weigh in one side or the other. And very quickly on that same point, with respect to the balancing analysis, the city has had, by my count, 2 or 3 opportunities to present evidence to the supervisor. There was the original request in 2014. There was another request in 2017. There was a remand by Judge Henry from the Superior Court. The city was given 3 opportunities to present specific instances, specific facts in which this information would pose some risk of harm, of scam, of some identity theft or otherwise, and that was not done. So the court's record.
The Registry of Motor Vehicles has a lot more information than just driving records. They have title records, they have registrations, and so forth. Does the DPPA govern any of those, or is it only the driving portion?
The DPPA speaks a little bit more broadly than particular, let's say, data points of information, Your Honor, in that I won't quote the statute here, but if you'll bear with me, it is words to the effect of information that identifies the driver, and then it has various examples, kind of a non-exhaustive list of the types of information at issue. And if we're using a certain canon of construction that indicates that items following a generalized term tend to limit that term, then we can assume that the DPPA is limited to certain information by implication. But again, Your Honor, if I could come back to the fact that the DPPA's interests now, I take Justice Hodgins' point that that statute does not apply here and that we're not so concerned with the DPPA, even though it's a major part of Somerville's brief. The interests that are articulated and are the focus of concern in the DPPA have been adequately addressed, and I would say even more than adequately addressed by both the supervisor and the motion judge. And in fact, the motion judge was under no obligation to consider the privacy interests articulated in the DPPA. It is a flexible, discretionary balancing of case-specific factors. And the judge in the Superior Court actually says in her opinion that she acknowledges the DPPA does not govern here, but she says she will consider the privacy interests as part of her balancing analysis. She did exactly that. She concluded that there was a moderate, her words, moderate privacy interest in the vehicular information, license plate number, registration, make, model, year. And that is why the motion judge carved that information out as being beyond the public interest, beyond public access.
Could you articulate the public interest and respond to the argument that there's no public, well, essentially that there's no public interest unless there's already some allegation of wrongdoing?
Yes, that's the chicken and the egg question, Your Honor. In that, as Justice Hodgins, I think, pointed out, how would you know there's wrongdoing if you don't have any information to base that wrongdoing on? And that's the mass landlords case. I would point out that that was a Rule 28 decision of this court. So it has no precedential value, of course, but it may have some persuasive value. But, Your Honor, I'll let the SJC answer that question for us, because there's not just one public interest in play here or in any other case. Again, it's flexible. The supervisor and the motion judge both had the discretion to use whatever public interests were legitimate in their estimation. And so we're not just talking about the ability of citizens to monitor the government to make sure the government is doing its job adequately in a law-abiding manner and efficiently. Let's look at some of the other public interests, all valid, pointed out by the SJC, and this is in the DPA.
Well, let me just ask you this, as you're running out of time. So I just want to make sure I'm clear on this. If there is someone who's watching, let's say, a particular vehicle parked and is curious as to, well, I wonder who that young woman is who's parking that car there, has his eye on her. If this information is released to the public, would that person be able to determine who that young woman is who's parking that car there?
I don't know how that would happen, Your Honor. I don't know how that would happen.
Okay.
Your Honor, I didn't fully answer your question. Would you like me to very briefly finish with the
If you
few
could, yes.
items? All right. This, Your Honor, is an answer to your question of other valid public interests here in play. This is from the DPH case involving the Boston Globe at pages 448 to 52. Here are some of the public interests that the SJC articulates are valid in this context. Ensuring the government is recording and maintaining data accurately, learning about government operations, reporting on the government, verifying facts to improve that reporting, studying trends in government statistics, ferreting out voter fraud, determining the quality of public housing, providing injured parties with accurate information about owners and operators of vehicles. So we have a panoply of public interests in play in this case that map onto the interests articulated by the SJC. So there is a substantial outweighing of the privacy interest to the extent there is any privacy interest in the names and addresses of the individuals at issue. I thank the court for its time, and I thank you for the extra time, Justice Singh.
Thank you. Thank you to the parties. The case is submitted. We move now to the next case, which is impounded. The number is 24P796. Give everyone time to get settled.
Of course. Good thing I didn't get another coffee. I would have started talking already, Justice.
You can begin.
Thank you. Good morning, Justices. My name is Jared Spinelli. I'm from Rubin and Rudman, and we represented the husband in the underlying judgment of divorce in the probate family court. What I want to spend my time this morning on is to focus mostly on how the trial judge calculated, in my opinion, in error, his alimony obligation to his former wife. There's an interesting, in my opinion, a potentially novel issue that was existent at the time of the 2023 trial, which was how his executive compensation materially increased as a direct byproduct of the COVID-19 pandemic. He was a named officer and an executive at the company, and the company just so happened, they fell into it, they were the ones that had the most sensitive diagnostic SARS-CoV testing material. And their share price prior to the pandemic was always static, around $90, $92 a share. And this is just to evidence what it is that I say, which is that after and during the pandemic, but after the discovery of this testing technology and the ramp up of the manufacturing, their share price more than doubled. Yet, because this is a temporal increase, which was great, it was a boon for everybody, but it was temporal, it was finite. By the time of the trial in September of 2023, it was now down to $85, and all of this is uncontroverted from a fact standpoint.
The wife, in her brief at pages 15 and 16, gives what I consider a concise list of the assets. And I'm wondering if anything on that list is in dispute, and if so, what?
Sure, Justice D'Angelo, let me just take a look.
Sure.
I don't believe the list of the assets is in dispute, and I don't believe that was part of my brief either. So I think the direct answer is no, Justice. But just getting back to this calculation, because I think it is relevant, I don't think anyone's disputing that this was a special circumstances alimony case akin to Young. No one's disputing that. However, it was how it was impacted, because there is also no dispute from the evidence and from the facts that the husband was paying himself at every moment when they were in the money, when they could execute these stocks to add additional compensation, which was materially benefiting both parties. He was paid by his company in three ways: traditional base salary, traditional cash bonus. What we're talking about here is the third component, which was a long-term incentive program, LTIP compensation. That was a 3-year vesting type of structure, and LTIP compensation was comprised of stock options, restricted stock, and performance restricted stock units over a traditional 3-year vest, a third, a third, a third. And so that 3-year vest really propelled them in tax years 2020, 2021, and 2022. And as an aside, but I do find it noteworthy, the court might want to consider a civitas analysis and also under Young as it relates to a marital lifestyle, that by the time they separated, which is also uncontroverted, in August of 2020, the highest incomes that this gentleman realized was post-separation. But back to his income for purposes of alimony. At the time of the trial, as I said, it was down to $85 a share, which was only it was down 31% over the course of 6 months, which was also uncontroverted. And so we also know how he was paying himself over the course of the prior years. He was selling as often as possible. There is a finding of fact, several, 102 to 109 from the trial judge, that backed up the fact that he had executed nearly $2 million, $1.9 million over 3 years, again, because they needed to afford their lifestyle, which was too, in my opinion, and I think factually speaking, too grandiose. They could not support it based on his own cash base salary and cash bonus. He testified, and this testimony wasn't challenged, that by the time of the trial, the 2021 and 2022 granted stock options had a negative value. They were worthless. He couldn't execute. So he was only receiving his cash salary and his cash bonus. He also testified, and again was not challenged, that the stock price boon was a thing of the past. People, and we understand this just from a layperson standpoint. We were all testing aggressively in the early parts and the middle parts of the pandemic, but as that waned, people weren't running to buy these testing kits anymore. They used to be out of stock all the time at our local pharmacies, but now you can get them at any moment. He also testified, and it was not challenged, that as an executive, he was subject to insider trading rules, blackout periods via the SEC. And he also testified, and it was not challenged, that he had to maintain 2 times his base salary, and his base salary was $485,000. So he had to maintain $970,000 worth of stock. But as you can appreciate, the less the stock is worth, the more shares he had to keep to maintain that $970,000. The trial judge, I don't think, and this is my inference, completely understood the nature of his non-cash equity compensation. And the fact that He could not continue to execute these stocks under the LTIP comp to continue to be paid what he was paid over the last several years of the marriage. The judge in this case took a number of $997,000 and $977,000 and change for his compensation for purposes of alimony. He cannot pay that. There is no ability to pay that. And there's also a very factual circumstance here that by the time of the trial, he wasn't even working for that company any longer. The company had been partially spun off. It had been sold, and he was now working along with a reduced amount of his staff at a new company. And therefore, this idea that he was still being able to pay himself the way he was during the latter part of the marriage, it was simply not the case. The judge's rationale does not talk about the impact of the pandemic at all. It is missing. It's devoid. The judge doesn't say, I contemplated, but I decline, or the judge didn't say, conversely, that she took credence in these facts. There was nothing in the rationale findings of fact that had any contemplation about the fact that there was this very clear and calculated increase temporally in his compensation, and the fact that he testified, and it was uncontroverted, that by the time of the 3-day trial, it was back down and actually below. It was now no longer had any value, those shares. So I think that was plain error. I think that was improper.
Where did that number come from? That 977,885. Because it's pretty close to the Medicare wages in 2018. But it's not.
Sure, Justice Hodgins.
So
I think what it was, and to the judge's credit, because I understand this is a complex set of circumstances, I believe it might have been the lowest of the prior 7 years that he earned at the prior company. And so while I appreciate that, I don't think that goes anywhere near where it should have been in recognition of two things. He wasn't working there anymore, number one. Number two, he couldn't sell his shares to supplement and get that $485 base salary plus a couple $100,000 because there was a cap on a cash bonus, 60% of his base. He could not continue to execute to get up to $1 million. It was impossible. So to rely on that, and if you think about it, it doubled what his temporary alimony support was. The parties got it right at the temporary.
I'm a little confused.
Sure.
So are you disputing that the income of the husband per year was almost $998,000 a year?
I'm not disputing the history of his total compensation during the latter 5 years of the marriage, Justice D'Angelo. What I'm disputing is his ability to continue to make that total amount of money from the three buckets. Because his salary was $485, there's a 60% cap on his cash bonus, which gets to about $750. He used to be able to supplement and get up and over $1 million by executing because they were in the money. The times were great. They were both making more money. The lifestyle was the best it's ever been. Granted, some of this was after they already separated, but for purposes of this argument, he was still able to supplement in 2020, 2021, and 2022. But by the time of the trial, he couldn't execute. He'd lose money. Nobody would ever execute shares when they're 85 when they were granted at 92. You're not making any money. So I'm not disputing his history. I think it speaks for itself. It's on the Social Security earnings statement. I think no one disputes that. Justice Singh, sorry.
So you don't dispute the history. You don't dispute what the judge laid out in terms of the numbers. But you're saying, just to be clear, you're saying the plain error was you believe that the judge did not consider the impact of COVID and what's happened with that on the
Certainly, that's number one. Yes, there was no explanation, no impact of
because there was no specific mention of it.
nothing.
So we're to believe if there's no specific mention of it, it wasn't considered.
I have nothing in front of me, nor do I think Your Honors have anything in front of you that shows that she was contemplating that fact. And then there's a second material point, which I'll just emphasize by repetition, which is he was no longer working there by the time of the trial. And it wasn't like he was laid off, he didn't quit, nothing like that. Sometimes we see those types of cases here, Justices. His company was spun off. and this new company did not come with that gravitas. There was uncontroverted testimony that his team was shrunk from 16 to 6. There was testimony that was not challenged that his budget, because they make their money by acquiring on M&A, mergers and acquisitions, that his budget to do so was materially shrunken. So there was no ability for him, at least early on in this time, to grow the new company like it was at the old company. So he, in essence, he was still making a good living, but there was no way, from an ability to pay standpoint, he could ever get to what it was. And if you look at what the if you look at what the judgment for the alimony order, $4,000 a week, that was 43% of his gross salary. And the testimony and the evidence from the trial record from his financial statement was he couldn't even support himself.
So you don't contest, to echo Justice Singh, the 998 history of the salary?
Uncontested, Justice.
What evidence was presented as to, at the time of trial, what his salary was at that point in total?
Yep.
What was the evidence?
There was ample evidence in the trial record, pay stubs, Justice, offer letters, employment from the...
How much? What's the total of what you submitted as the salary?
It's the same. They gave him the same salary that he had at the prior company, $485, because there was a spin-off. It wasn't a brand-new company.
Maybe I'm not making myself clear.
Sorry.
I'm a boilerplate kind of guy.
Yes, sir.
So the judge said $998 per year. Put all the columns together, $998.
Yes.
What is your argument as to what's that grand total at the time of trial that she should have used? What was the number
Correct.
she should have used?
Thank you, Justice Angelo. I hope I can directly answer your question now. I started to say earlier, the parties got it right in the temporary stipulation when they agreed that he would pay a fixed base alimony from his salary, and then if, as, and when, right, so this is a special circumstance, we don't dispute that, if, as, and when he received additional compensation, the former wife would receive a percentage. And we also don't dispute the percentages, just to be clear, if you hear from my sister later, the percentages are also not disputed, 21%, 20%, that's fine. But it's an ability to pay argument, which is if, as, and when he realized additional compensation, he would be more than willing and happy to pay it because it's a long-term marriage. That's what our statute deserves and governs. So that's what they did for 2 years.
What's the number?
Yep. So the number would have been, I apologize if I'm not being directly responsive, Justice D'Angelo. It would have been approximately $2,000 a week, which is what he was paying under temporary order. So she essentially doubled it as a mandatory base guarantee, which was 43% of his base salary. So I think the only thing that would have been consistent with Young, what should have happened, is that we followed that same rubric. And if, as, and when he received it, he would have paid it. I don't think the trial judge's analysis was consistent with Pierce, right? I don't think there was a fair balance of sacrifice under these facts. I don't think there's no balance of sacrifice. He was ordered to pay more than 43% of his base salary. His financial statement revealed he wasn't even able to support himself, let alone his former spouse. And Pierce tells us that there should be a balancing of that sacrifice.
Counsel, I know this isn't necessarily part of the appeal, although I guess it could be. There's nothing preventing husband, after the judgment, the following year or something, say, you held $998,000. Here are all my stubs. I'm only making $400,000 to go in and ask for a recalculation, correct?
Yeah. Correct, but the trial court expects us to wait to demonstrate that because you can't just come in the next day, right? So that would be inequitable. That would be unfair, I would posit, Justice D'Angelo. Just because we talked a lot about alimony, I will rest on my brief, but there were on the division of assets, I just want your honors to be aware that there were miscalculations and errors in math that even my sister acknowledges. In their reply brief, their red brief, there was a mistake where the trial judge put $79,000 as a withdrawal when it was a deposit, and the trial judge forgot to include the $250,000 advance in her calculations. On the first day of trial, they each took $250,000, and the judge overlooked that in her findings, which is material. So I see my time is up. I'll rest otherwise on my brief, and I appreciate the justice's time.
Thank you.
Thank you.
May it please the court, good morning. My name is Nancy Freed, and I, along with my partner Anna Martinetti of Prince Labelle, represent the appellee Kathleen Glasgow-Turow. Your Honors, we are here requesting that you affirm in all respects the judgment of the Probate and Family Court. I'm confident that you've reviewed the record below. There are 149 entries on the docket of a case that spanned from July of 2020 to judgment in March of 2024. It is clear in deciding whether there's an abuse of discretion that the court must determine whether the disposition constituted action which no conscientious judge acting intelligently could have taken. There is a basis in the record, throughout the findings, and I will point out some of the inaccuracies in my brother's argument, that the judge considered all of the factors that she was to consider in setting both the alimony award and the division of assets. In my brief, I set forth the husband's earning history at page 34. And we go back to 2017 all the way through 2023.
Counsel, opposing counsel has agreed that the history is right. And again, I'm looping it together, again, boilerplating it all, $998,000. He agrees that historically that's correct. The argument he's making is that at the time of trial, the numbers had drastically changed, almost by 50%. That seems to me to potentially be an abuse of discretion there. So can you talk about where he comes up with basically a 50% erroneous amount?
The numbers, Your Honor, had actually dramatically increased. And if I go backwards to the husband's Social Security earnings, in 2022, it was $3,648,569. In 2021, it was $2,703,000. In 2020, it was $2,113,000, and I'm rounding to take off the hundreds. In 2019, it was $1,682,000. So in fact, it is the inverse. The judge used the lowest Social Security earnings, and that was from 2018. In 2017, his Social Security earnings, Medicare wages, were over $1 million. In 2017, 2018, 2019, most of the world had not heard the word COVID. 2020, if his argument had merit, one would say that his 2020 earnings, which were $2.1 million, were only at the beginning of COVID. So while the husband would like to conveniently construct an argument that it was COVID, yes, his income went up, yes, his stock was more valuable, but the judge used the lowest number that she could have used, and that was the $997 in 2018. At the time of trial, husband, and in the court's findings, at finding number 82, the 2023 LTIP, which his compensation summary, the target was $1,552,000, which was $485,000 in base salary, $291,000 in bonus, and $776,000 in LTIP. She was quite conservative in using the lowest number and the number prior to COVID.
But just the selection of that number, I mean, it just strikes me as somewhat arbitrary. Like, why, and I'm still trying to understand why that number was picked.
Why the 997? Because I think it was the lowest number from 2017 to 2023, to the time of trial.
Yes, but if he's submitting financial statements that indicate his income is now, let's say, $490-something thousand a year or something in that range, I mean, why couldn't she have just picked one of those numbers too?
So what I think my brother is arguing is at the time of the temporary order, there was a support order that was 24% of his base income and 24% on everything above his base income. So the order was self-modifying on everything above the base. What she did was she took base, bonus, and some part of the LTIP. She looked at all of that compensation together, and rather than paying the bonus and the LTIP on an if, as, and when basis, she fixed a number at $997. My client at the time was earning $26,000. She subtracted that, and she took approximately 21% of the difference between the $997, which was his income, $26 was hers. But what the judge did is, rather than having it self-modify from everything above the base, she included all of the other components. She also, importantly, she ordered that the wife would retain the marital home, and she ordered that she was to refinance it. It had a significant mortgage on the time, and there would have been no way that the wife would qualify for a refinance based upon what was the temporary order on base only, which was approximately half of what the final order would be when you considered all of the components. She also considered young, and it was clear, so there were findings throughout, that the wife needed alimony. She was entitled to alimony. It was a long-term marriage. It had durational limits that would be consistent with the ARA. But she looked at young, and she determined that the wife's needs were $333,000, which were the numbers set forth on her financial statement. She ordered a payment at $208,000, which was insufficient to meet the wife's needs. She then ordered additional alimony, 20%, on the amounts above the $997, but she capped it at another $125,000. So while the husband's brief suggests that she wasn't in compliance with young, she was in compliance with young because it met needs, and if the husband's income had been $3.6 million as it had been in 2022, if it had continued to be that high, then it would have exceeded the needs.
What do you say to counsel's argument that there are basic calculation errors in the judge's judgment?
I disagree, and I suspect that what he's referring to is in one of the charts that we submitted, we said that there was a subtraction of $39,000, and the judge included it in her findings. To the extent that there was an error, it was de minimis and insignificant. The husband's brief and in his argument keeps referring to that the judge failed to consider a $250,000 distribution to each of the parties. She considered it. It's in her findings. There are multiple places in the findings that say, and I'm trying to find the page, that considering all of the advanced distributions, that she was still making the following judgment. So the record has several references to her consideration of the advanced distribution that was made on day one of trial. My brother, in his brief, also argues that the judge abused her discretion by not permitting the husband to file a financial statement on the third day of trial. I do want to point out that trial began on September 29th. There was a second day of trial on October 10th, and there was a third day of trial on November 20th. So more than from October 10th until November 20th, more than 40 days had lapsed, during which time that the husband would have been able to provide counsel in the court with a financial statement, but rather counsel handed it to me and attempted to file it at that time, and the judge did not allow the filing of that financial statement. The husband was on the stand, and counsel had an adequate opportunity to inquire of his client as to any changes that there might have been at the time of his testimony. And in addition, the substantial change seemed to be the $250,000 distribution that each party received, which was accounted for in the court's judgment. In his brief, my brother argues that the judge abused her discretion in ordering a 75-25 division of the children's educational expenses, which we believe was also appropriate given what was the substantial disparity in the net after-tax income for the husband and net after-tax income for the wife. My brother also in his brief argues that the judge abused her discretion by not ordering the parties to file a joint 2022 tax return. As I understand the law, a party cannot be compelled to file a tax return with another, and unless there was a court order to the contrary or an agreement to the contrary, the wife in this case had no obligation to file joint tax returns with the husband, nor did she have any obligation to pay the taxes on his income. There is an argument set forth in my brother's brief that suggests that the court did not make independent findings, and that essentially she calls it cut and pasted our findings. It's an interesting argument because, as my brother has pointed out, both in his brief and in his argument today, that the court made a mathematical error that we didn't make. So clearly, her findings were her discretion. She considered all of the discretionary and mandatory factors, and we believe after a long case and a lengthy trial and 149 entries that she made the right decision. She did not abuse her discretion. She did not commit an error of law, and we are asking that you affirm her judgment in all respects.
Thank you.
Thank you.
Thank you to the parties. The case is submitted. The next case on the list is Alexander Thayer, Jared Gosselin, 24P444.
Good morning, Your Honors. Richard Latimer, Falmouth, Massachusetts, appearing for the plaintiff appellant Alexander Thayer. If I may just get right to the point, we are appealing because of what appears to be, if not an error of law, abuse of discretion by the trial judge in both admitting prejudicial evidence against Mr. Thayer and excluding non-prejudicial, relevant, and competent evidence against the defendants.
Counsel, can I ask a procedural question? Is it fair, based on what you just said and based on the brief, you're not appealing any post-judgment motions or any findings that were made post-judgment?
Excuse me.
Are you not appealing any post-judgment motions that were made and decided? It's only the trial issues?
Your Honor, I'm appealing everything that is appealable on this. So,
Well, the notice of appeal only mentions the judgment on directed verdict and the judgment on the jury verdict. There's nothing in the notice that suggests anything post-trial, and it wasn't really addressed. I just want to make sure what we're all discussing here is correct.
yes, Your Honor.
Okay, thank you.
Now, to look at the admission of the district court order revoking probation, there's no evidence that Mr. Thayer saw that. I didn't, because, frankly, he told me that his probation was revoked because he didn't have He didn't appear a few times for his probation, with his probation officer. I had no reason to doubt that. I saw the notice that he received, so that's what we went with. But ultimately, the reason why his probation was revoked is not relevant. Was not relevant, was not material to any issue in the case.
Well, isn't it relevant to his credibility? He put his credibility at stake during the trial by saying he was only revoked because of one factor, when in reality he was revoked for other factors. So why can't that go to his credibility that he was not being completely honest with the jury?
Your Honor, it's interesting, though, that it was irrelevant when he said the one thing what it was. Why didn't these defendants object to that? They could have. They could have said, objection, Your Honor, irrelevant. Fine, that won't get in. That would have been sustained. No, they were setting a trap for him, knowing what he believed to be true and what he would testify to.
So is part of your argument that you were not provided a copy of that decision in discovery, and therefore it was improperly admitted on that basis, or?
I have to acknowledge the fact that this was impeachment evidence, yes. But I still would say that this was ambush evidence, because even though we didn't ask for it, they knew what he was going to testify to. And again, if they really thought that it was important, they should have told us about it.
I guess that's, you mentioned that in your brief, but how are they supposed to know what your client is going to testify to? Can't
because he sent that through discovery.
Well, can't they assume that if a question is asked, why was your probation violated, that he's going to answer to what's on the docket, the finding? They assume he's going to tell what's on the docket.
Well, Your Honor, let me move on from there. Assuming that this was admissible, that this was fair, assuming that, the argument is that the judge erred in admitting that and or excluding the evidence of the defendant's prior statements. And if we look at Rule 803, 803A says explicitly that agency statements, findings of fact, statements, observations of fact are admissible. What these are were statements made by these defendants against their interest. Those are facts.
And the judge let you admit certain statements of the defendants. It was just that the entire report was not admitted.
No, Your Honor, he didn't let us admit any of it. All I wanted to was to cross-examine these defendants on their statements, as in the reports. That was what was excluded. And if we look at Rule 803C, the only thing that the exclusion for investigative reports only applies to conclusions made by the investigators, opinions, statements of law, and things like that. These were simply statements of fact that I wanted to cross-examine these witnesses on, these defendants on. I wasn't going to read the whole thing into evidence. I wasn't going to read into anything about what the investigators thought or what they concluded or their opinions. I just wanted to say, didn't you tell this investigator blah, blah, blah? And see how that's what was excluded. I wanted to confront these witnesses with their prior inconsistent statements, inconsistent with what they had testified to.
So not just, you're arguing that they were not just admissible because there was...
Excuse me, Your Honor.
Oh, I'm sorry. Your argument is that they were also prior inconsistent? Because you're arguing that they were admissible as statements of a party opponent, but they were also going to be prior inconsistent statements?
I'm not quite getting the question. These were statements made by defendants which contradicted what they claimed about what happened. For example, and some of what they claimed that happened was ridiculous anyway. Oh, 5 officers just went up to that interrogation room to compare notes. This was, and getting back really to the point here is this verdict was against all the competent objective evidence, both direct and circumstantial. The direct objective evidence shows all of these officers going up. This is a search of one individual looking for alleged drugs on his person. And there wasn't just one search, there were 2 searches. And there was physical violence used in the second search. And there was objective evidence of that, being the bruise on Mr. Thayer's rib, over his rib cage, where Gosselin slugged him. That's objective evidence. The jury didn't even think of that, didn't consider any of that. Why? This jury of 6 women and 2 men heard only that Mr. Thayer was a wife beater. That's all they heard. And that doesn't, and the exclusion through, what is it, 403, you exclude evidence where it has a tendency to be unduly prejudicial, even if it is highly relevant on that issue of credibility. You exclude it because it had that tendency to be very prejudicial, and we saw from this verdict that it was. And how can you know from the verdict that it was prejudicial? Because the verdict was against all the competent objective evidence. Photographic evidence, circumstantial evidence. Oh, Mr. Thayer went through the screening machine when he went in there, no drugs were found. But yet when they take him up to this small room and interrogate him and beat him, oh, the machine was down on that day. They search him thoroughly, and then they leave, and then they take him into another room with a toilet. Oh, then they hear it flush. Now, they say, well, he disposed of the drugs. But let's consider the fact that the drugs that he was alleged to have had by this inmate Wood, who, by the way, was not the most reliable and credible witness on which to base probable cause, but this inmate Wood said he kept the drugs in a sock. So what did they think? He had a sock stuffed up his anus? That's the only place it could have been hidden.
Are you asking us to disagree with the jury verdict?
Excuse me?
Are you asking us to disagree with the jury verdict?
I'm asking to disagree with the judge's rulings and to, yes, not to just overturn the jury verdict because the jury verdict was not obtained through a fair proceeding. It was obtained by prejudicial evidence being admitted and relevant evidence that was helpful being excluded, which, by the way, happened to be contrary to all the objective evidence. So I'm not simply saying because it's contrary to all the objective evidence that should therefore be excluded, but what I'm saying is when you look at all the objective evidence combined with the prejudice from this judge's rulings, prejudicing Mr. Thayer by allowing that district court order into evidence and or prejudicing Mr. Thayer by denying counsel's right to cross-examine these witnesses on what is in fact admissible evidence, the fact that the verdict was against the weight of all of the objective evidence is just an additional fact establishing the prejudice. Whereas a different jury that didn't hear this, if Mr. Thayer had simply come in and truthfully said, yes, I was in jail for probation violation, and without more, I would suggest to you that a very different verdict would have very likely been obtained, because there would be nothing there for the defendants to come back with prior bad acts or which that evidence was about the district court order, was clearly introduced with the intent to establish prior bad acts, which, if this were a criminal defendant, that would be excluded, on its face. So the fact is that where the objective evidence is all in Mr. Thayer's favor, where if a jury had looked only at the objective evidence, there's highly probability that he would have prevailed on his complaint. But what the jury did instead was, as induced by defense counsel, punished Mr. Thayer for being a wife beater.
But counsel, when you talk about the objective evidence, you're talking about injuries, and there was no dispute about that those injuries existed. But the question was, how were they sustained, right? And there were alternative explanations offered at trial, correct?
Well, Your Honor, they denied beating Mr. Thayer, for example. Now, but when he got to the infirmary in the evening, there was a red bruise exactly where he was hit. He testified also that a day or so later, Gosselin punched him again in that same area. And then when he finally got to have a full, complete medical exam, the nurse verified that it was either a very bad bruise or a fracture, a slight rib fracture. And again, the things that defendants cite as to Mr. Thayer's credibility. Oh, he lied when he went to the infirmary the first time. Yes, he lied. He said he fell down the stairs or something. Well, that's because Gosselin told him, keep his effing mouth shut. So that's why he went to the infirmary, and that's what he said. He went to the infirmary. He didn't say why he actually, how he actually was injured, because he was intimidated, which again is part of the complaint against these defendants, that what they were doing was they were intimidating him, they were going after him on the slimmest of evidence, most likely, don't know, but most likely because of the same reason they were aware of the order that he was an alleged wife beater. And the fact is, that was never proven by a trial. That was dismissed. So, again, stating it simply, we are asking for a new trial because the first trial was clearly not a fair trial for Mr. Thayer because of the prejudicial introduction of evidence, the prejudicial exclusion of his evidence, and it is contrary to all of the objective evidence that supports Mr. Thayer's testimony as to what happened.
Thank you. Thank you.
Thank you.
Good morning, Justices. Good morning. My name is Michael Donovan. I'm the General Counsel for the Bristol County Sheriff's Office. I appear today on behalf of the Sheriff's Office as a Special Assistant Attorney General. I was not trial counsel, so I don't have certainly the advantages of Attorney Latimer in terms of a memory of the events, so my arguments are based on my reading of the record. I would argue to Your Honors that this was, in fact, a fair trial. The juries are presumed to execute their duties diligently, to take the evidence and the instructions of the judge when weighing what happened, and I would ask the Court not to disturb the jury's verdict. Getting, I would suggest, straight to the main arguments that seem to be made on behalf of the plaintiff, that the judge improperly admitted the docket of his probation surrender, and that the judge improperly excluded the SIU report. With regards to the docket of the probation surrender, as Justice D'Angelo, as you pointed out, the plaintiff put this into play himself. When you read the trial transcripts, it seems pretty clear that central to the plaintiff's strategy was attempting to elicit sympathy on his behalf from the jury. The first witness he calls on his behalf is his mother, who has nothing to say about what happened in the House of Correction, but is rather there to tell the jury about her son, a pre-existing injury, his struggles with narcotics. When the plaintiff himself testifies, it's not just a passing comment. There is a significant portion of his direct examination testimony that's dedicated to demonstrating to the jury that he's basically just a good man down on his luck. And the reason that his probation is surrendered is that he misses 2 appointments with his probation officer. And he explains to the jury the reason he missed those appointments is that he had a fiance and a young child at home that he was supporting, that he was working extra hours as a car salesman, and that the requirements of that job in order to get his commission checks necessitated that he missed those appointments with his probation officer. He then goes on to testify that essentially surrender issues, he's brought into court, the probation officer makes a recommendation to the judge in district court to hold him in custody, and that's the whole reason that he's held. It paints him essentially as a victim of an unsympathetic system that's out to get him, and it is also manifestly untrue. In fact, he had been charged some days before he was held with a domestic violence charge against that fiance. And when you look at the dockets of the 2 cases, and they were both admitted, the plaintiff admitted the docket of his credit card larceny case, that was Exhibit 16 at trial, and then the defendants admitted the docket of the assault and battery on a family or household member, that was Exhibit 17 at trial. The claim that's made here...
Why was Exhibit 17 relevant to anything?
It's relevant because of his statements to the jury. Central to this case, I would respectfully disagree with counsel's assertion that the great weight of the evidence is in support of the plaintiff here. The only evidence in support of the plaintiff is his own testimony. There's an argument to be made about the injury, but I would suggest that that could cut one way or the other depending on what the jury takes from it. So plaintiff's credibility is central. There are other points in the record, and I'll get to those if I have time, where there are what I would suggest lies or mistruths that he admits to when he testifies.
But doesn't the probation notice and what the judge found in his or her findings for the surrender, I guess I understand that the plaintiff opened the door to that. But what is the fact that the actual docket of the charge have to do with anything? You're saying it comes in to affect his credibility, that he lied by saying he was surrendered for, I'll use the same terminology, X. And you want to introduce, well, it wasn't just X, it was X and Y. I get that. But it seems like you're adding fuel to the fire by saying we're also introducing the exhibit of that charge, which, by the way, ultimately gets dismissed. Why was that admissible? That's not what was proven at the probation surrender. There was actual evidence, which is the finding.
Right. Well, I would suggest that at first he attempts to deny that that's the reason for the surrender. And then he, meaning the plaintiff, testifies when he's asked just about the fact of the reason, he starts testifying about the underlying facts. Oh, she was lying, she made it up, she recanted immediately. It's very difficult when you read the transcript to get a solid answer out of him what happened. And that's why I think having the exhibit itself is important, because you can compare the dates on the exhibit, the docket of the assault and battery case, and compare it to the dates of the docket that he submitted on his own behalf, the credit card case that he was on probation for. And the dates themselves, I would suggest, are evidence that he's not telling the truth when the claim is made that he doesn't know why his probation was surrendered, or that he honestly thought.
Did the judge give a limiting instruction to the jury at the time of its admission that it could only be used for credibility?
The judge did not give a limiting instruction based on my reading of the transcripts. The judge gave essentially the standard instructions on credibility at the end of the case. The two things I would say about that would be, one, no limiting instruction was requested by the plaintiff at the time that these were admitted or at the charge conference before the case went to the jury. And second, while I would concede that potentially a limiting instruction would probably have been the better practice here, it doesn't represent an abuse of discretion that requires a reversal of the jury's verdict, especially where, when you read the transcript, the argument is that the way it plays into the trial is because of, is how it impacts the plaintiff's credibility before the jury.
Okay, let's turn to the SIU report. You agree that the findings that are contained in that report, not the conclusions, but the findings of fact, those are admissible, correct?
I would suggest that I would argue that the opinions of the investigator are not admissible, that they're inadmissible hearsay.
What about the findings of fact, which are the statements made by the defendants and presumably statements made by the plaintiff? Those are admissible.
Those are admissible. So
why was it not an abuse of discretion for the judge not to let in those parts of the report?
Because the judge would have let those parts of the report in if they had been appropriately presented. So, for one, in this case, each of the defendants who were witnesses wrote their own individual reports, and I believe those were actually admitted. So those are part of the record. When I look at the transcript, and I'm referencing Volume 4, Appendix Volume 4, it's on page 121. There's a sidebar where there's a discussion with counsel, and the judge says at sidebar, the ones, they're talking about whether the SIU report can be admitted. He says, the ones from the SIU report are by a third party. They contain the statements of some of the individual defendants, which I have indicated to you I would allow you to get those particular statements in. But the statements of the opinion of the investigator are not admissible. They are not admissible under any field. So, respectfully, I disagree with counsel's contention that all he wanted to get in were the statements of the defendants. When you look at the motions and you look at the arguments, he was trying to get the whole thing in. And the judge stated on the record that he would let him get those statements of the defendants in. When I look at the record and I look at the record of cross-examination and look at the record of the trial, I only see one point where counsel attempted to cross-examine one of the witnesses with his interview with the SIU investigator. And I would submit, it's in my brief in more detail, but I would submit that the question itself was improperly phrased. There was an objection which was sustained, and then counsel essentially left it alone.
Well, the question is, and this is at page 150, I think it's volume 5. Do you recall being asked by the SIU investigators as to why 6 people were required to conduct this second strip search? Objection. Sustained. Why is that not admissible, again, as a finding of fact? I'm assuming the SIU investigator actually asked that, and there was an answer to that question.
Well, when you look at the report, I don't believe that the witness actually did answer that question from the SIU investigator. And the witness at this point had testified at trial that only 2 people were in the room during the search. So the question itself is trying to back in an accusation made by the SIU investigator that's never adopted by the witness.
I'm missing it. If an investigator asked him during the investigation, why were 6 people required to conduct this second strip search?
Right.
Regardless of whether he's previously testified that there were 2 or 3, that seems to me to be a proper question. Were you asked that? The answer could be yes or no.
Well, the question
says, do you recall? That to me is a yes or no answer. I recall it, yes, or I don't recall it, no. If that is in the report, I'm not sure I understand why that objection was sustained. It's going directly to a question it seemingly asked in the report.
Right. So my argument would be where the SIU investigator himself had been an individual that the plaintiff said he was going to call a trial, and he never does end up calling that investigator a trial, that what the question is trying to do is sort of as a backdoor introduce testimony from the SIU investigator when it's a statement that was never adopted by the witness.
Where in the case law does it say that the question has or answer has to be adopted by the witness? My understanding of the case law is that the findings of fact in a public report are admissible, period. Not the opinions, not the conclusions, but the findings of fact.
Well,
so isn't that a finding of fact if they ask the question and they get an answer?
I wouldn't agree that it's a finding of fact. It's a question being asked by the investigator. And when you go back and look at the SIU report, I don't believe that that witness, when he was being interviewed, ever answered the question by the investigator. So I would disagree that a question by the investigator in the report constitutes a finding of fact.
All right. So I'll assume you're correct. Why is asking him if he just remembered that question being asked? Why is that not a proper question? Again, the answer is yes or no. If he doesn't recall, presumably the lawyer could show it to him to refresh his recollection, or if the answer is yes, I remember it, well, then we go there. I'm failing to understand why this objection is sustained, which is exactly what counsel is saying, is that I wanted to ask questions about this investigation, about what they were asked, and I was not allowed to.
Well, unfortunately, when the objection was sustained, counsel moved on. So even if it was an improperly sustained objection, there isn't any discussion at sidebar or attempt to rephrase or attempt to pursue the point that would shed any light on the trial judge's reasoning there.
Are there any other questions and answers that you could glean from the transcript that went to the issue of being asked about the investigation to any of the witnesses?
There were none that I could see.
Okay.
So that was the only example. And I would suggest on that point that even if Your Honors were to find that this was an improperly objected to question, because it's one incident and it's moved on from quickly, that if there is an error there, it would be harmless when you look at the rest of the evidence.
And I know your time is running out. I'll ask you the same procedural question that I asked opposing counsel. Is it your understanding that the appeal has nothing to do with any of the post-judgment motions that were filed?
The appeal, it seems as though in the brief, it looked to me as though he was challenging the judgment notwithstanding the verdict, the denial of his motion for new trial. It seemed to me as though he was pursuing those. Based on his argument, it doesn't appear that he is at this point. But just as a general matter, I would suggest it's a similar abuse of discretion standard. And when you look at the evidence I would suggest contradicts, for the most part, what he says about what happened. So I see my time is about to run out. Unless Your Honors, Justices have any further questions, I'll rest on my brief.
Thank you.
Thank you.
Thank you to the parties. The case is submitted. At this point, the court is going to be in a recess. So we'll proceed with the remaining cases. The next case on the list is Timothy Burke versus Town of Dennis, 24P 1021.
Good morning, Your Honor. Assuming it's still the morning, I didn't bring my cell phone into the court today. My name is Tim Burke, and I'm representing a trust that I established for my children. What is at issue here is an undeveloped lot in the town of Dennis, Massachusetts. The record is replete with discussion about the neighborhood and that type of thing, but just to make it very brief, because I think most of the facts at issue here are procedural and not as to the land itself. There's an undeveloped lot in a fully developed neighborhood in Dennis. Sure. It is thank you very much. If you can't hear me, just let me know. It is an undeveloped lot in Dennis. It is a fully developed neighborhood. It's got a long history, but as it relates to what we have here is that there are two prior decisions of this court relative to this property. It was brought before this court on issues of whether or not the Superior Court could hear the case, as whether or not the Superior Court had jurisdiction. It was determined that two things were required, basically. One, to put in for a building permit, which happened here, and the other go to the land court. And that happened here as well. So a building permit was requested, the application was filed. And by the way, the language in this court's prior opinion specifically states the dentist can give an advisory opinion for reasons unbeknownst to me that seems to create great consternation to my opponent. So the issue here is, what do we have? We have a piece of property that is governed, at least it relates to this matter, by a 50-year-old bylaw that has never been discussed at an appeals court. And the language which is at issue, and we're all taught never to look down on the statute, so I'll do the best I can, but I actually want to read the statute and be correct, is that it says that, but shall not affect such rights or duties that have matured, penalties that were incurred, proceedings that were begun, or appointments were made before its effective date.
So you'd agree that's sort of a grandfathering provision, right?
In essence, it really
Okay,
is.
and so what was it about that property that had matured before that bylaw was adopted?
Well, what had matured is that, looking at the history of the case, that all the properties around there were built. And there's a whole record. I don't want to get into property A, property B. If you read the record, they're all built outside what would technically be called, most of them are technically all called, was allowed, let me try it another way. There was a lot of building done outside the term of what otherwise would be acceptable. There's multiple reasons for that. And I'm in the horns of a dilemma here, in that I filed a motion to expand the record here as they had at the prior court. What has happened here is that the evidence as to whether or not a building permit was applied for on this building is an unknown. And the reason being is that this is the third case, there's been discovery in all three cases, and discovery responses have differed regarding. There was no evidence provided in this case about a prior building permit. In other cases, and when I stitched the record together, there was a show that a building permit was approved subsequent in 1992. There was work done. There's never been an explanation as to.
But can we go back to, what was it, 1973?
Absolutely.
Can we go back
I'm sorry,
to?
I digressed.
Yeah, sure. Can we go back to October 24th, 1973? That seems to be the date where the parties' rights would be fixed, right?
Give or
Under
take.
that section of the bylaw. Okay, so on that date, what was it about that property, such as, a building permit, something, there was something in the works that we could hang our hat on and say, well, the rights of the party had matured at this point. What right would that be?
Well, they had a right to build on the day of the enactment, the October date. and that has changed, by the way, during the case, as of that date, they could have built on that property. There's no question. What is an unanswerable question at this point is whether, answering your question, I don't want to keep going back to it, we don't know whether or not the gentleman owned 4 lots, put in for 4 building permit applications, or just one, 2, or 3, or 4. There is evidence that there's 3. It makes no sense he wouldn't do 4. So I'm trying not to get into that too much. I'm just trying to stay on the legal issue. But with the idea being...
I think that is the legal issue, is to reiterate Justice Hodgins' question. If something had been done on that date of October 1973, either something had actually been built there, a building permit, something, then you would be grandfathered in. The question is, if nothing has been done since that date, it's still just a vacant lot of land, there was no building permit allowed, what's matured? What allows you to say, I'm grandfathered in?
Under the prior zoning rules, you could build.
Oh, but
And if the
that's not a grandfather. That would allow you to ignore any law by saying, well, it used to be this way. In
It would not.
the 1700s, I could build whatever I want, but now I can't.
It would not, because the way the statute is drafted, it gives you the rights that have matured, and you had a matured right on that date to build. So it's not as if something went back to colonial time. It refers, and again, the language here, which is part of the argument, is not clear.
Wouldn't that make every zoning decision wrong? Then, if you're saying you're grandfathered in because at one point you had zoning rights and therefore you have zoning rights forevermore in that property, that wouldn't allow a town to ever change its zoning laws.
It depends on the language they adopt.
Well, let's use this language.
Right.
So in this language, if at one point you were allowed to build on an acre of land, okay, that's what it used to be, and then the town later on changes it to you need 2 acres of land. You think you can just say, well, I used to be able to build on an acre, so I can forever build on an acre?
Well, Your Honor, I answered the question. What you have to, I believe what the law states, is that you have to look at extrinsic evidence. It was 50 years ago. How did they interpret this statute back then? We're looking at it from eyes, and this year is 2025, of course. We're looking at it 52 years almost after this statute was enacted. So what did they think at the time? And the extrinsic evidence all shows that property was allowed to be built on. Across the board, whether it was a zoning, whether it was a variance acceptance or not, because of the limitations on discovery. Can I have 1 second? Because we know the limitations on discovery, we don't know how many properties were built on as of right. So what we...
Okay, but even if what you're saying is true, all right. That a zoning board or a building commissioner back in the 1970s was a little more lenient, and even though it said 20,000 square feet, if people came up short of that, they were still issuing permits. That's not binding on a future building commissioner or zoning board. I mean, they're not, there's no stare decisis with...
No, I'm not alleging it's stare decisis. It's, what it is, though, is it provides a context, some substance as to what this means. This language, by the way, you do the Google search, you do all the searches in the legal databases, is unique to this property, it's unique to this town.
Well, I think I would suggest the grandfathering provisions are pretty standard. The language itself might be a little bit different, but and the reason for that is you have to have some kind of grandfathering in there because you can't be taking people's property without compensation. So if there is a zoning bylaw amendment, it makes sense that you're going to have a special provision for people who in this case, they use the language of matured to protect people who might have something underway, let's say.
But
Someone who has a permit that they have and they just have not started the build yet, it's not going to affect people like that. There's going to be something there. If it's just an unimproved parcel, though, that unimproved parcel will be subject to the new bylaw if all other things are equal. Would you agree with that?
in this case, I don't, because of two reasons. One, we don't know whether he put in for a building permit. And second
I'm
of all,
sorry, I didn't hear that.
we don't know whether Mr. Drake, who's no longer with us, put in for a building permit because the records have been lost. So we don't know. We actually don't know whether there's a building permit put on this property. There's no way to have certainty here as to what happened. My case is not the record keeper. Mr. Drake is not the record keeper. The town has an obligation to keep the records.
And whose burden is it to show?
Excuse me?
Whose burden is it?
Well, my argument is the way that this court has ruled that extrinsic evidence, if the language is ambiguous, the town has to come forth with some extrinsic evidence to support it. They haven't done that.
But again, you're starting with the ambiguity.
Right.
What are you saying is ambiguous? From
Okay, so
reading your briefing, it sounds to me that you're saying that the language, rights that are matured,
Right.
simply means rights that existed, that you're equating the two. Rights that are matured are rights that existed.
True.
So that if you had the right to build at that point in time,
Right.
all your rights are matured. So you maintain that right to build at any future time.
Yes.
Okay.
But because it's what the language says. It's the rights are matured. Granted, we can argue what the term matured means. You're judges. I'm just the guy standing here arguing for matured. But what else could it mean? If you had a right to build, you had a right to build. You own the land, you had a right to build. That's the simplest interpretation.
Let me ask you this. Is your lot presently conforming or non-conforming?
Presently, it's not my lot, by the way. I set up a trust for my kids. I want to make clear. I
Okay,
don't know
whosever
anything.
lot it is it conforming or non-conforming?
Under the current rules, no.
Under the current rules, it's non-conforming.
Correct.
You agree with that?
Yes, I do.
Okay.
All right, so maybe I'm following this. If Mr. Drake obtained the property prior to 1973, okay, I see your argument that when he bought the property, the zoning law didn't exist, and therefore he had certain rights. Maybe that's what the law means by matured. I'm not necessarily agreeing with you, but let's say that. But once he conveys the land to someone else, they're on notice that the zoning law has now changed. So why aren't they, whoever Drake sold it to, it looks like Barbara Hall, trustee of so-and-so, at that point, they're on notice that the zoning law has changed and it is now this. Why aren't they on notice and therefore the zoning law applies to them?
Because when you assign property, you assign the rights to go with it. You're trying to separate the rights. If he had a right to build the land, if he put in for the building permit, then that right would transfer. I understand your notice argument, but the right, once you have a right with a piece of property, it stays with it. And if I could say one thing, I have 1 minute and 7 seconds left. What is also very troubling here is that there were a lot of things that were limiting discovery. Motion to strike was allowed on a summary sheet in the underlying documents, all of which showed what the town thought this meant at the time. Granted, it's not precedential. It is not, all of those decisions are not precedential of them by themselves. But it does give you a flavor, a context as to what was understood at the time. Summary sheets are widely allowed in trials. I do tax work primarily. If you can tell I don't do zoning work. They allow it in all the time. It's just a courtesy to all judges. Nobody wants to read 1,000 pages of credit card statements, or 2,000 pages of bank statements, that type of thing. They come in all the time. So my suggestion is, by keeping it out, all that does is lead into the question of what's allowed for extrinsic evidence. I am at 1 second. I thank you for taking the time. I hope that you will find for the trust. Thank you very much.
Thank you.
Good morning. My name is Robin Stein. I practice at KP Law. We are town counsel to the town of Dennis, and I'm representing the appellees this morning. This case sets forth a very straightforward question of an interpretation of an unambiguous zoning bylaw. General Law, Chapter 48, Section 6, in the first paragraph, essentially sets forth when you carry pre-existing non-conforming status. And that is when you have a building permit that has issued, a special permit that has issued, or a use that has been made. In this case, we have an undersized lot that was held in common ownership at the time that it became undersized. It merges with abutting land, and it is not buildable. And there are no facts that would bring it within any of the protections that I just referenced. In addition, it falls outside the protections afforded by General Law, Chapter 48, Section 6, Paragraph 4, because of the common ownership factor. And when we read that law in conjunction with Section 1.9 of the zoning bylaw, which references a mature right, there is no reasonable interpretation of that language that could be anything other than a right that has come to fruition, a right that has been used. If you say a mature right is a right, you've read the word mature out of the bylaw, and that is inconsistent with how the law interprets statutes. In this case, we simply have a lot that is not buildable.
So let me ask you a question. I'm going to flip it
Sure.
ever so slightly. If on January 1, 2025, I buy a piece of property, and at the time I buy that property, it's allowed for 2 homes.
Sure.
Okay? The next day, the zoning law changes, and it says you can only build 1 home on that property. Clearly a change. Under this, am I grandfathered in?
No. No, because the only time that you carry legally existing non-conforming status is if you have an issued building permit that you timely use, or if you have a use in existence, if you're exercising it. So in this case, even if a building permit had timely issued for this property in 1973, the evidence is it is vacant, and that building permit now would not afford them any legal protections under General Law, Chapter 48, Section 6. Now, we recognize that zoning bylaws can be more generous, but that's something that has to be explicit, and certainly this simple reference to a right that has matured, it's not any kind of explicit indication that the town meant to forever freeze anything you could have done but didn't do, which is essentially Mr. Burke's argument. In addition, it ignores Section 2.3.1 of that same zoning bylaw that spells out the dimensions that you need to meet at the same time that Section 1.9 is there in order to obtain a building permit, and the initial change was to 20,000 square feet, now 40,000 square feet. This lot, under the law, is simply not buildable. Section 1.9 is not ambiguous. It is susceptible to clear interpretation. In making our arguments before the land court, we in fact used the dictionary definitions offered by Mr. Burke. We didn't even offer different definitions. That we're talking about a mature, first of all, even if a dimensional requirement is a right, which I question as opposed to a use, whether or not the reference to rights that have matured can even apply to a dimensional change, I question, but even if it could, they didn't have a mature right. They had a vacant piece of land. And when you look at the law that actually applies to this case, when you do practice zoning law, you'll see, for example, that the other 3 lots that Mr. Burke owned that did receive building permits received those in September of 1973, meaning they had issued building permits prior to the adoption of the zoning change. They have a legally different status. They weren't allowed to be built inappropriately. They were protected because they had issued building permits. Those are different lots with different law.
All right, let me ask you this, because it is something that the plaintiff said that I am sympathetic to. You know, with these local boards, they change all the time and so forth. Building commissioners come and go. There does seem to be some potential for unfairness here if, let's say, the plaintiff realizes, okay, I fought this fight for a long time, I'm at a dead end, I'm just going to sell this for what I can, sells it, and then someone else comes along Now it's a local person who has the favor of some people on the local board, and voila, suddenly the building permit issues. What do you say to that?
Well, I mean, I don't foresee that possibility of that here. First of all, there's a couple things to keep in mind. We did, through discovery, investigate the board's records, and they had never interpreted this section before. So any notion that the zoning board has acted inconsistently or differently is simply not true. The fact that a prior building commissioner, without the zoning board being involved, may or may not interpret a zoning bylaw a certain way is not imputed to the board. But the board today has said, this is how we read this section. I don't foresee how they could simply say we read it differently. And it's important to keep in mind that there is an avenue for obtaining zoning relief when you have an undersized lot that in 3 lawsuits the plaintiff has never attempted to avail himself from, and that is to apply for a dimensional variance. And again, I don't think this section is remotely ambiguous, but the evidence that the plaintiff is relying on tells you it is not ambiguous. The board heard and issued over 100 variances, dimensional variances, in the 1970s after this change came in, from over 100 people who came in and said, the law changed, now I'm undersized, and now I need a dimensional variance. Many of those they granted, some of those they did not. There is no evidence of bias, there's no evidence of favor, and there's no claim of that in this case. I am sympathetic to your question, but it is not a fault of the town or the board that there's a legal avenue available, and I don't know if Mr. Burke would apply for a variance if he would get one or not, but he's never tried, and he doesn't respect the difference in this case.
So even though it's, so when we say it's not a buildable lot, that's not necessarily cast in concrete.
It's not buildable as of right. So what this case is doing is asking you to read the zoning bylaw and say you have an absolute right to come in and pull a building permit. This lot is buildable as of right. However, you can always ask for a dimensional variance when your lot is undersized. Mr. Burke has not done that and does not appear in this case to respect or understand the difference in those permitting routes. Again, the best evidence of what the town thought of this change in 1973 is that it renders these undeveloped lots not buildable, or why would the zoning board hear 100+ requests for variances in the immediate aftermath? Now, I think all of that variance information is irrelevant in this case, and I think it was proper to keep it out of the case, but even if the court were to consider it and take it in, it doesn't change the result. You have an undersized lot, it was held in common ownership, it benefits from no legal protections, it's not buildable, and how many variances may or may not have issued or why has nothing to do with the legal analysis in this case before this court. The land court got this case 100% right. It was made needlessly complicated based on the legal.
But it might play a factor in the future should he apply for a variance in the future, and if 99 other properties in the area received the variance under the same circumstances, then that would be relevant.
Well, I don't actually agree that it would be relevant for 2 reasons. First of all, there were denials, there were grants. The other issue is that the law on variances changed in 1977, 1978. The Zoning Act was recodified, and this change came in 1973, and many of those variances were granted under the prior standard, which I haven't delved too deep into, but I did take a look in the course of this case, and I believe that it had not the same hardship requirements that we currently have. So putting aside the fact that every application for variance needs to be evaluated on its own merits, and the boards have to find, the requirements, and that's not what's before us. The avenue exists. I can't say what will happen if he applies for one, but I don't think at all that what happened in the 1970s ultimately requires a grant or a denial now. I don't think it has any bearing. The point that I'm making is what's at issue in this case is this property buildable as of right? And under the law, under the bylaw, under 40A, under the town's bylaw, this property is not buildable as of right. It does not factually benefit from any of the circumstances that would give it any kind of legally existing status. It was a property that Mr. Burke, in his capacity as trustee, acquired at a time that it was not buildable. Due diligence would have told you that. That is a known decision that you make when you acquire property, to look into those things. It shouldn't sway how any court or the town treats the property. The bottom line is it doesn't have a mature right. It's an undeveloped property. Nothing's been completed or brought to fruition, and that's simply the status of this lot. I'm not, in my mind, it's a simple legal issue. This is how zoning is regularly applied, and much of why we're here, why this case is before you for a third time, has to do with in my opinion, the plaintiff not fully understanding or grasping these different components, continuing to rely on variances for proof that your property is buildable, I think is a mistake in the law. And I think, again, the land court properly limited discovery, properly limited the record. Again, what's before you is a zoning board's decision. It's not what happened with a building inspector many, many years ago. And the board in this case did exactly what the board is supposed to do. The board got the answer right. The land court got the answer right. The land court properly limited discovery, properly limited the summary judgment record.
Well, if we disagree that the language is unambiguous, then did the judge's rulings on discovery impede the plaintiff's ability to make his point regarding the proper meaning?
No, I don't think so, because what the plaintiff is looking for in discovery is irrelevant information. So, for example, variance decisions are not relevant to what the bylaw means, except to support our position. I mean, realistically, the only reason a variance decision in this case would have any relevance, it is the best evidence that the zoning board believed variances were needed. Variances are only needed if the lot is not buildable. So limiting how much more of that the plaintiff has is not going to hurt the plaintiff. In addition, how other town departments treat this property has nothing to do with zoning. So whether the assessor assessed it as a buildable lot or not, or whether the Board of Health granted a septic permit or a variance or anything else, has nothing to do with the zoning question. So any more amount of discovery into how other departments treated the properties, what happened with other lots, all of that is irrelevant to the question before the court. So I don't see that. And I do think the court, even if this was ambiguous, the court had plenty of information in the summary judgment record to make a decision that the property is not buildable. But that language is not susceptible to different meanings under how the law applies to zoning. It's simply not. And I hope in the end that you'll agree with me, but there's nothing ambiguous about that language. There's nothing that could give it different meanings. In order to agree with the plaintiff, you have to read the word mature out of the bylaw, and that is not consistent with the statutory rules for interpreting language. In order to agree with the plaintiff, you would have to find that that was an explicit indication from the town that it intended to expand the rights under 40A6. And it isn't, and it can't be. And so, no, I don't see how any additional information the plaintiff is looking for can possibly have bearing on this case, because none of it is legally relevant.
As far as maturity rights go,
Yes.
would you agree that, again, I don't want to go back to 1973. I'll use my simple hypothetical of yesterday, I got a building permit
Sure.
for property. Today, the law changes and says, for whatever reason, that building permit, again, zoning, you shouldn't have gotten it. Would that be maturity because I obtained the building permit?
So under General Law, Chapter 48, Section 6, that would be maturity for 1 year. So the statute says that if you have a lawfully issued permit, and not to make it complicated, technically it has to do with when the public hearing was noticed, but under your analysis, yes. So if you have the permit and the bylaw amendment changes and applies to you, the law actually gives you 1 year to use that permit, and if you don't use it within a year, then you're susceptible to whatever's changed in the meantime. So the law is accounted for that.
And that's what maturity
Yes.
sort of means. Okay.
So in this case, there's no evidence of a permit in 1973, but even if it was, it doesn't help. And whatever happened in the 90s doesn't help either. The bottom line is that this lot is still unimproved. It's simply an unimproved lot that was held in common ownership and merged in October of 1973 when the amendment changed. And other than that, I will rest my papers. I don't want to take up more of your time to repeat myself.
Thank you.
Thank you.
Thank you to the parties. The case is submitted. Call the next case on the list, Joseph Caparelli versus Brian Arrigo, 24P 1182.
May I begin? Good morning or afternoon, Your Honors. My name is Harold Lichten. I represent the plaintiff, Chief Caffarelli, in this case. The settlement that was made in this case was non-controversial. It was eminently fair and proper because my client, Joseph Caffarelli, had been a model police officer and police chief for 25 years, had an explicit contract allowing him to return to his lieutenant position should he no longer be permitted to remain as chief. And such reinstatement provisions are the standard for municipal police departments. I used to represent many municipal police and fire unions, and no one would take the job as a chief getting out of civil service if they didn't know they had a right to come back if a new mayor came in and appointed someone else. So that was the provision in his contract that he could go back. When Chief Caffarelli settled his lawsuit against the city of Revere and its mayor in 2022, the agreement was very carefully negotiated and in an abundance of caution for the unlikely contingency that the retroactive granting of 2 years of service credit, which we strongly believe he
Counsel, can I get to what I think is the language that's at issue in the agreement? How do we square with your position where the agreement specifically says that their parties have not made any guarantees or assertions to the release or as to the approval sought from the City of Revere Retirement Board?
Yes, and the settlement also says that the settlement agreement is not effective until both the retirement credit is granted and the court approves the settlement agreement. So that effectiveness shows, and this was the argument before the court, that the settlement never became effective, and that's one of the grounds under Rule 60b-6 for granting a reopening. It's true that it wasn't guaranteed, although it was a very standard practice, but there was a contingency specifically written into the agreement for that very problem, or the very potential problem, which I didn't think was a problem at the time, that if it was not granted, the settlement was not effective. And the settlement never became effective by its own terms because, for whatever reason, that part of the agreement was never effectuated. That gets me to what I believe. Now, one thing I want to point out, that this whole issue of whether this should have been approved by PERAC or not, as we pointed out in our papers, this was a standard practice, and we pointed out to you cases where such relief had been granted in other cases. I wanted to quote from your decision in Town of Hull Retirement Board versus Contributory Retirement Appeals Board, which said, and I'm quoting, "The board further argues that there is no explicit authority permitting it to change a member's effective retirement date. This claim is without merit. Nothing in the language of Chapter 32, Section 7, Subsection 2, limits a retirement board's ability to redetermine the effective retirement date and recalculate retirement benefits if circumstances so require." So all that happened here was that we had a very strong and meritorious argument that Chief Caffarelli had a contract to go back to work as a lieutenant if his chief's appointment was not renewed. That was a claim before the court.
Yes, but doesn't the retirement board have to be a party to the litigation? I mean, it seemed, I mean, if I'm putting myself in the position of the retirement board, and all of a sudden, like a bolt out of the blue, someone says, hey, you've got to award a few more years to somebody, and they haven't been paying into the system and so forth. I mean, that would strike me as, well, says who?
Well, two things. First, the retirement board is actually controlled by the mayor, who was the party to the case and settled the case. Retirement boards are, the majority of appointments are by the government itself. The retirement board actually cooperated with us. What happened was, it's in the record, is that they calculated what would have to be paid in. We weren't trying to get something for free. He was going to pay in the money he would have paid in had he not been, in our opinion, unlawfully terminated, and that was $22,000, and he paid that money. He actually wrote out a check, sent it to the board accepted it. It was this issue that PERAC somehow argued that, no, in order to do this, he would have to pay back the 2 years of retirement or 3 years of retirement money that he had already received, which would be hundreds of thousands of dollars, and that's where it broke down. So I'm not sure it was really the retirement board that was surprised and was upset about this. In any event, I'm not really arguing that, because I think the issue here is this was accounted for. This isn't a case like some Rule 60b-6 cases where there was a mutual mistake and there was no contingency for this. What I'm relying on in this case is that we specifically negotiated this issue, and there was a provision that said that this whole agreement does not become effective until the retirement credit is granted and the court approves it. And we also took the precaution of having the Superior Court judge look at the settlement agreement and approving that part to grant him credit. Now, the thing broke down, didn't anticipate that, but I say that under Rule 60b-6, this is the exact situation that calls for all we're asking for now is reopening of the judgment. We're not asking for anything else.
But what about the stipulation of dismissal? It sounded pretty final, where the parties stipulated that all claims asserted are dismissed with prejudice, all parties waiving rights of appeal and rights pursuant to Rule 60.
Yes, and that's exactly why Rule 60b-6 is there. In all the Rule 60b-6 cases, what you have is a final either a judgment or a settlement with dismissal with prejudice. That's what all the cases are. And the question is, are there grounds for reopening that? And we pointed out to you the McKendy case, which is the leading case of the Supreme Judicial Court. We've pointed out to you other cases. The First Circuit case of Boss, which talks about the fact that Rule 60b-6 is made just for this situation. I just wanted to. In Boss, the court said, this is the First Circuit decision in the United States versus Boss. It says, quote, "It is well settled and accepted that material breaches of a settlement agreement which had been incorporated into the judgment of a court entitles the non-breaching party to relief from the judgment." And in the Keeling case, which we also cite versus Local 167, there the Keeling agreed to make certain payments to a union pension fund. Those payments were subject to approval from the bankruptcy court, which never occurred, and the court held that Rule 60b-6 was the appropriate vehicle to open that up. In all Rule 60b-6 cases, you're saying that there was a final judgment, but there is extraordinary or unusual grounds that justify reopening of the case. I suggest to you that this is a quintessential case where that should be effectuated, because.
But maybe this isn't the case. Maybe the more in other cases it may be that simply reopening the case makes sense. But in this case, that might not be the situation because of the other parties involved that need to be brought in.
No, but that's what I'm saying. We have not suggested that any parties have to be brought in now. Originally, we tried to bring in parties. It got very complicated with other parties. The court saying, well, I think maybe there has to be new proceedings. Just so we know, we were 14 months in the Superior Court trying to get this resolved. We were before the court in August of 2023. Then November of 2023, the court said it was going to push it over to another judge. Then we were before the court in April of 2024, and there was not a decision. And the decision by the Superior Court judge just focused on the retirement boards. We're not asking for anything regarding the retirement boards or PERAC. We're saying, look, the idea was that there was going to be the settlement agreement. There was going to be 2 years of creditable service, which is a very fair part of the settlement. It did increase my client's pension, and that was a material aspect of the case. We paid the money that would be required to get that pension credit. That was not effectuated. I'm not blaming for why it was. Therefore, the case should simply be reopened. I'm not asking for any of the retirement boards to be brought in. We just want to go back if we have to pay the money back that we got. And we already had a judgment for about $90,000 because we did win on some of the wage claims, and there was triple damages under the wage claims. So that's all we're really asking for, is to go back and have a trial on the case of what I believe is an extremely meritorious case, and under Rule 60b-6, one of the things you look at is there a meritorious case? And that's why I started out by trying to explain that this was he should have gone back to be a police lieutenant. For whatever reason, they did not allow him to do that, and getting an enhanced retirement benefit, which is standard. When you look at various statutes involving wrongful termination, a very common aspect of all such cases is the getting retirement credit, because that's something you can't get back without a court order, and it's something that's very valuable to someone. And his argument was, I would have worked 2 more years, that was my plan, and I would have retired. And all the parties agreed to this, and as I said before, we actually wrote this into the agreement that the settlement would not become effective until that went into place, and it never did go into place. And that's why I think Rule 60b-6 applies. Happy to answer any more questions, but that's my basic argument.
I just have one question. Is there a reason for going the retirement route, just getting the enhancement of benefits rather than just assigning a dollar value to that and having that as part of the settlement from the city? Is it? I'm just trying to figure out. Is it the city doesn't want to just write out the check and would rather just have a retirement board take it over time, or like what's the dynamic there?
Well, that's an interesting question. At the time, it seemed like it was a win-win for both parties, because instead of paying what we thought was owed to him of hundreds of thousands of dollars, they paid a lot less than that, but then could string this amount out over an amortized amount of time. And I want to be clear, we weren't trying to game the system at all, because we paid the money. We got $22,000 of the settlement went in to pay for this, and the retirement board accepted the money. The attorney for the retirement board was very cooperative, and then Herrick came up with this thing that he would have to pay all the money back that he'd gotten on retirement, which no one had anticipated. I assume if it goes back, which we hope it will, we assume that that might be an alternative way to deal with this, and at this point in time.
Thank you.
Thank you very much, Your Honors.
Good afternoon, Your Honors, and may it please the Court. My name is Matthew Hamill, and I'm here on behalf of the City of Revere and Brian Arrigo. And I am respectfully asking this Court to affirm the judgment below in all respects. Justice Hodgins, I'm going to jump right into this by addressing a question that you asked, and that was relative to the stipulation of dismissal and the finality that is attendant with such a filing. Plaintiff argues that the settlement never became effective. I think that is an overly narrow reading of the settlement agreement. So plaintiff focus, I would suggest, on paragraph 2 and the effective date provision of that settlement agreement. If you just look one paragraph up in paragraph 1, paragraph 1 states that upon the effective date of the settlement agreement, I believe the language is the plaintiff shall file a stipulative dismissal with prejudice and waiving rights of appeal in 60B on the Superior Court action. The plaintiff or the parties did that in a joint filing prior to that second portion of the effective date becoming effective. I believe that is a clear waiver of the effective date provision in the settlement agreement, and I frankly think it's insurmountable as to this appeal.
What about the opposing counsel says that there was a condition precedent, and the condition precedent being that he get his retirement benefits? I'm paraphrasing. Is that in the agreement?
I don't, Your Honor, I don't know if a condition precedent language is in the agreement, but I will point to the language that you pointed out, Your Honor, earlier, that the parties expressly contemplated for this non-occurrence. The language, again, this is in paragraph 2 of the settlement agreement, was that the releaser expressly acknowledged that the city made no guarantees or affirmations as to the approval sought by the retirement board, which is a third party.
Is the agreement actually anywhere in the record? The actual settlement agreement?
It is, Your Honor. The actual settlement agreement is Joint Appendix 2 at page 75.
Thank you.
Yes. So, Your Honor, to just continue on that point, again, I believe the stipulated dismissal with prejudice is
highly decisive in this case and dispositive. To touch on a few other issues raised by my brother, and maybe to frame this by discussing some areas where we agree. The settlement really reached below was fair. The parties agree on that. The plaintiff does not argue below and does not assert on appeal that the city has in any way breached the settlement agreement. And I think, and I think my brother's argument confirms this, the relief that's sought is far beyond the scope of that which was sought in the underlying action and is really focused on a dispute with PERAC. The city bought its piece, paid a settlement. That settlement was executed and the plaintiff filed a stipulation of dismissal, and I believe that is highly relevant in this case. As to plaintiff's argument under Rule 60b-6, Your Honor, it is true that one of the aspects that a court may analyze in reviewing a motion under Rule 60b-6 is the relative merits of the case. A court can also analyze whether the substantial rights of any party will be affected by granting the motion. And here, again, based on the apparent focus on the decision of the Retirement Board and PERAC, I do believe that reopening this litigation that the city settled, that the city paid a substantial sum of money to settle, would adversely affect the substantial rights of the city of Revere, and I believe the motion should be affirmed on that ground.
But
go ahead.
your brother's last point was that this was something that neither of the parties had contemplated. And so isn't that the classic case in which a case should be reopened?
I don't believe so, Your Honor, and I think that's memorialized in the settlement agreement because the parties did expressly agree that this could happen. They expressly agreed that there was a chance that or at least the city did not make any affirmations as to the affirmance sought by the Retirement Board. So under Rule 60b-6, and I know my brother raises impossibility and frustration of purpose, in order for those doctrines to apply, there needs to be a basic assumption on which the contract was based. And I think the fact that the party specifically memorialized the fact that the city made no representations or affirmations as to the actions of the board in the settlement agreement, I think shows that the parties agree that this was not a basic assumption and not something that the parties fully expected to happen.
What about if terms in a contract seem to be inconsistent with one another? In looking at the agreement, and I guess this is where opposing counsel gets it, it says the effective date of the agreement is A, the court enters an order, and B, the City of Revere Retirement Board approves the agreement and confirms that upon receipt, Caffarelli will be credited. So that wasn't done, correct?
That's correct, Your Honor.
So how do we say that the agreement is effective when the contingency B wasn't entered into?
Certainly, Your Honor.
It certainly goes against what I pointed out and what you go, which it says that you're not making any assertions as to what the City of Revere Retirement Board will do.
Certainly, Your Honor.
Are those inconsistent?
Your Honor, your point is well taken. I would suggest again that the plaintiff's action in dismissing his case before that effective date came into place constitutes, I think, a waiver of that settlement term. And I would also suggest, Your Honor, that in the settlement agreement is an invalidation clause that's in paragraph 5, which states that should any provision of this settlement agreement be deemed invalid, the remainder of the settlement is enforceable as against the parties.
Well, that might be true if a certain provision is not met, but it seems to me if the agreement is not effective, if we say that that paragraph applies, that makes the whole agreement sort of null and void, doesn't it?
Your Honor, I don't believe so, and again, I would go back to our waiver argument, which I think is probably our strongest argument on this point. And a waiver can be discerned by the court by unequivocal, clear, decisive conduct that evidences a party's intent to relinquish a right that they've had. And I can think of nothing clearer and more unequivocal than dismissing your case prior to that term being satisfied.
So if he hadn't signed the stipulation of dismissal and had the court enter it, you would agree that these inconsistent terms, a provision wasn't met, and the case would have gone on?
Your Honor, I would agree to the extent that I would even submit that if it was a stipulation of dismissal without prejudice, we would be in a different procedural posture, but that's not where we are. This is a stipulation of dismissal with prejudice, waiving appeal rights and waiving 60B rights. And the plaintiff now wants to reopen his litigation against the city when there's no dispute the city can't offer the relief that he, at the end of the day, really seeks.
You know, I'm just trying to think of if this were a former employee and I were the city, and neither side's admitting any wrongdoing, but we've reached this arrangement where the city's going to be paying some money, and it's anticipated that a third party is going to be also throwing some money in here. Just out of fairness, it seems to me, if I were the city and I'd want to treat this employee fairly, if something went wrong with that process, I'd try to make it right. That, well, okay, maybe there's a technical issue here. Maybe you shouldn't have agreed to dismiss it until we're absolutely certain that the check was in the mail from the retirement board. Why is there no inclination on the part of the city to try to resolve this and say, okay, well, it looks like we both, you know, anticipated there was going to be more money coming into the settlement. It didn't work out. Let's arrive at a figure that is mutually agreeable.
Certainly, Your Honor. And I have a few points to address that. Number one, and again, I would just suggest the city did not necessarily anticipate this was going to happen, and they memorialized that in the settlement agreement, stating that we do not make any guarantees or affirmations as to the board's decision. And I think the second point, the relief that's being sought here, namely the retroactive retirement date, and I understand Your Honor's point that at the end of the day we're talking about money. I do understand that point. But the relief that is being sought is not relief the city can offer, and the city paid its settlement payment based on the disposition of the claims at summary judgment, and I think at the time that was accurately reflective of the position of the case. Unless the court has any further questions for me, I will respectfully rest my brief and request that this court affirm. Thank you for your time.
Thank you to the parties. The case is submitted. And the final case on the list is JM versus AM. Parties can approach.
Good afternoon. Matthew Barak for, may it please the court. The lower court here erred in three ways. First, by not entering a guilty finding of contempt against the former husband for his failure to pay the former wife for equal share of her proceeds from Custom Inc. options in the amount of $147,700 plus applicable interest. Second, the lower court erred by declining to take action on the wife's second complaint for contempt related to health insurance coverage by finding without explanation that the issue had been previously determined when it had not been determined under the amended judgment and the first judgment had not been docketed. Finally, the lower court erred when the husband was indeed found in contempt related to the stock shares in awarding $5,000 of a $56,000 award for legal fees. I'll start with the issue of the husband's failure to equally divide the Custom Inc. options, because I believe that is the story that leads to where we are today. The judgment is clear here. The father's $250,000 Custom Inc. options and all net proceeds of those options were to be divided equally between these parties. The lower court, the trial judge, when she made the judgment of divorce, was aware of the fact that it was unclear as to A, the value of these options, and B, critically, whether the father had exercised these options during the divorce trial. She had that knowledge, and despite having that knowledge, she ordered that these shares would be divided equally, and all the shares and its proceeds would be divided equally between the husband and the wife. I think the fact that this judgment is clear brings us to the second issue of whether there was a violation. And I'd start with this. The purpose of a contempt action in our probate court is to achieve compliance with court orders and judgments for the benefit of the complainant. That's critical here because...
Well, but counsel, in order to be found in contempt, there has to be a clear violation of the order.
Correct.
So what evidence is there that the husband actually exercised any of the custom link options?
Well, first, there was ample evidence. I actually don't even think it was disputed that the options weren't spent during the divorce trial. The father, actually, his argument was that absent evidence that he owned options after the divorce, he would not be in contempt. The evidence that was before the lower court was multiple exhibits of the father's exercising of those options during the divorce. What happened during the divorce trial was...
Doesn't it have to be after the divorce?
No.
The judgment entered, and after the judgment enters, there has to be a clear violation of the order. So it's post-judgment.
I agree that it's post-judgment. However, in the probate court, we have Rule 411. We have the rule that the party's assets are frozen in time until such time as until the judgment is rendered. You can only spend money for legal fees. You can only spend money for reasonable living expenses. What is interesting about this matter is the lower court judge was aware of the options, but the evidence had been provided to her during the trial that they existed. She knew that they were vested, and so she ordered them. The violation occurred during the divorce trial, but during the divorce trial, it was unclear to the parties, it was unclear what had actually transpired regarding with those options.
So I think this is where the probate judge got a little confused as well, counsel. It sounds like you're trying to attack the judgment, that
No.
she didn't consider these things that had been done. They should not have been done.
I disagree. And here's why.
Why?
I'll tell you, absolutely. Because I think that's exactly what the father here is trying to do. I think that if this judgment of non-contempt is allowed to stand, we're essentially saying to the probate court, you can do whatever you want during the pendency of the action. What this judge found on the contempt, and I'll give you an example. My example is if this is a house, which is an easier thing to understand than stock options. Let's say it's a house. Let's say it's only in the husband's name. The husband sells the house during the course of the matter. It's unclear what happened to the proceeds. It's unclear what happened to the house. But as part of that equitable distribution, the judge says the house proceeds go, half of those proceeds go to the wife. That's essentially what happened here. The judge here, the first judge, made a determination that this was an equitable division of assets. Equal division was equitable here. And as part of that division, it included these stock options. So to answer your question, the way I look at it is that's circular logic. Husband is saying, well, I don't have those 250 options. I don't have those anymore. I didn't have anything to exercise. I don't have to pay you. I do not believe that that's compliant with our existing law regarding contempt. And the reason is because the purpose, the very fundamental essence of a contempt is compliance with the court's order. And that order here, with all of that knowledge of what was going on, was for these shares to be equally divided between the parties, and that did not happen. His defense, he didn't, bringing it forward too, he didn't seek an appeal. He didn't seek to change the judgment. And why should Mrs. here seek a change in the judgment? There's no reason for her to seek it because she was awarded half the proceeds of those shares. My question is, why shouldn't she get paid at this point in time? That was the argument. And in fact, the second judge here found that it wasn't that he didn't have it. She found it wasn't proven by clear and convincing evidence, that it was willful. This is not a criminal contempt. This is a clear order with a clear violation where he's not arguing he didn't violate the terms of the judgment. He's just saying, oh, I didn't have to because of the fact that there was no options left. And I think that eviscerates any judgment in the probate court because it incentivizes people to get rid of assets. And that's why we're here. Because I think that if the second judge had followed the judgment, it was a clear order, it was unequivocal that he did it, and it's not for him now to defend it. I can't do it anymore because I didn't have to do it because I already had gotten rid of it. I think, to me, that's circular. And I think the complainant deserves the benefit here of the judgment that was entered by the first judge. I'll go to my second point, if I may. Okay, I will. The health insurance. The health insurance is fairly simple. The husband was required to maintain health insurance as part of the first judgment. The first judgment, the original judgment, there was a contempt filing on it. He was not adjudicated in contempt. That contempt filing was never docketed. So my client never had the ability to challenge it, to review it, to have an appeal. It wasn't challenged. Then what happens is an amended judgment enters, which changes some of the terms of the clause related to health insurance by adding dental insurance and a few other things to that clause. So now she's got no ability to challenge judgment one. She files a contempt. It goes to court. They have multiple days of testimony. It's 4 or 5 days of testimony regarding issues related to health insurance. It's clear the amended judgment says you have to have health insurance. It's clear that he had canceled the health insurance after the divorce. And what happens is after all this time, and there was a lot of time that went by, the judge says, well, I'm not going to address it. Essentially, she doesn't say the words res judicata, but I think it's implied. Our point is a couplefold. One, it was the amended judgment that she was seeking compliance of that wasn't determined by the court. Two, the judge did not explain why and how it was res judicata. Three, the judgment itself, original judgment of the first judgment, of the contempt against the original judgment, was never docketed, so it's not a final order. So therefore, the order exists. The finding was he had health insurance. He was supposed to maintain it, and to this point in time, he's never maintained it, and that's as simple as the argument is. Finally, on the issue of legal fees, the only reason we're here is because we discovered after the divorce what happened with these stock options where he's not adjudicated in contempt. There was 2+ years that went into figuring out what actually happened. During this trial below, there was testimony, brief testimony, it's in finding 89, about what had occurred on the divorce judgment with the issue of stock options, where the husband did not acknowledge the paper before him, which made the judge unclear. As a result, it took 2+ years of discovery, a discovery master, contempt filings to figure out what happened with the stock, what happened with the options. And what came down to it is ultimately there was a settlement right before the trial on the issue of the stock, which was about $600,000, $625,000, which was ultimately divided equally between the parties subject to the equitable divorce, plus interest, which was awarded. But what the judge doesn't address is the 2+ years that went into the legal fees to figure out what happened with the stock options, what happened with the stock, and what brought us to trial at the end. And what she doesn't, I believe, address reasonably or appropriately or properly is that there is a presumption for legal fees, as we know, when a party is adjudicated in contempt. Here, he was adjudicated in contempt. Here, the judge made a number of findings about his conduct throughout the action. The fact that she had to appoint a discovery master, the fact that she asked for, at one point, an accountant letter to figure this out, what had happened and what we were looking for, that took over a year plus for us to get. She did not weigh those issues. She did not weigh the fact that he was in contempt, and I believe a 10% award of fees when there's $56,000, all of which went in to procuring a judgment against the husband, should have been more properly addressed than the judge did, and is not commiserate with the egregious conduct and the bad faith that was committed below. Because the reality is, I'll finish where I started. If Mr. Mudd had paid my client the stock shares in the beginning, which he ultimately had to pay and was adjudicating contempt years later, if he had paid and shared the options which the judge required him to pay, I don't believe we'd be here today. And I think that's been the tenor of what brings us to this court.
Counsel, there was a finding made that says there was no, and this is about the option, there was no evidence presented during the divorce trial to enable the trial judge to determine whether husband had exercised any custom link options to date. What do we do with that finding?
I think it's an erroneous finding. I think when you go back, or when the clerks go back, and if you look at Exhibit G, H, and I, you'll see that that wasn't true. If you look at his own findings, you'll see that he didn't really deny the fact that he had exercised those options. His point was it was exercised during the divorce and not ex post facto after the divorce. If there's nothing further, I'll stand on my submissions.
Thank you.
Thank you, Justices.
May it please the court, good afternoon, representing myself. The fundamental issue in this appeal is that I'm accused of violating orders that did not exist when the alleged violations occurred. These are chronological impossibilities of law. The lower court understood the facts and the timeline. She properly rejected each contempt, clearly finding me not guilty. She wrote in her memorandum of decision, wife is seeking funds with interest from transactions dated January 13, 2017, so over 8 years ago, which is almost a year prior to the conclusion of trial, approximately 18 months prior to the date of the original divorce judgment, and almost 2 years prior to the date of the amended judgment of divorce. Wife did not prove by clear and convincing evidence that husband willfully and knowingly disobeyed the October 19, 2018 amended judgment of divorce. He is therefore not in contempt. I believe the judge went out of her way to give the court the language there to show the timing was dispositive and that I cannot be found guilty and no one can be found guilty of a contempt that allegedly was of an action that took place prior to an order. That would flip on its head what all laws are meant to do for due process, fairness, and more. In fact, there needs to be a clear and unequivocal order. There needs to be willful disobedience of that order, and there can't be such thing if you don't know an order exists, let alone years in advance. And this court requires abuse of discretion of the lower court to overturn that finding. So why am I here? Why not let the brief speak for itself? I came because I want to focus on the three most key ways that my information brings out the very important omissions and the confusing things that I believe are presented. Because if, like you had read what they read and thought, man, this guy sounds like a jerk, which is how I felt when I read the brief. I thought, who are they talking about? They're definitely missing a lot of information. I felt that was probably the same for someone else anonymously reading it, and I wanted to come in and critically prove these out. The first of which is they never appealed the judgment of divorce. They never filed any 60Bs. They have purely attacked me through contempts, saying that I was not in adherence to a judgment that they never questioned. They never appealed the judgment of divorce, and they never attacked it as a 60B. Now, I'm not a lawyer, but I've now gone through the laws very thoroughly, and I am certain that that was the appropriate thing that they should have been doing under these cases, because I've read the Carpenter case. They did not mention the Carpenter case. The Carpenter case is the only thing that I found that is entirely clearly like this fact case. This idea of a house that's discovered after the trial and whatnot. If you read the Carpenter case, which they do not mention and they didn't even address because I put that centrally in my brief, that case law speaks to why this court has contempts that can't be found after the fact. Because when something is decided in the court, and it was rigorously litigated, which I'm going to take you through how rigorously litigated our case was. It was a $800,000 legal bill that my ex-wife had run up before this council's new. The prior counsel who heard all of the case for 4 years, all the way through to 2020, so 2 years after 2018, after that judgment, had an $800,000 bill owed to her, to that firm. It was Kasner and Edwards. And simply, we will go through what the findings were, but when you go through all the findings, they're actually relatively clear. This was a rigorously litigated case. Carpenter applies. And the money that they're claiming now that they should get is an attempt to relitigate the divorce.
Sir, let me ask you, during the divorce trial, you redeemed, or it seems like the findings indicate that you redeemed some options and received a payment of over $295,000. Why isn't that a violation of the automatic stay that occurs during divorce proceedings?
Your Honor, I understand the question because it was begged through the briefs. Her counsel was very competent. They never alleged that because they knew that it wasn't, because they knew what I'm going to read to you was the finding. We were deeply in distress. We were spending through all of our assets, Your Honor. So what a 411 would require is that you have a factual finding that I didn't get the exact language he mentioned it, but you would have to be outside the caveats of what you can spend on. And as you read in finding of the divorce, page 96 of the divorce judgment, the judge found, Judge Ulwick, in the divorce, following the separation, so during the divorce, which was a 4-year divorce, the parties paid their living expenses and attorney's fees from their liquid assets, such that the only assets of significant value remaining are proceeds from the marital home and the original founder shares of Custom Inc. So the judge understood that what was happening was we were spending everything we had beyond our means, and I'm going to walk you through the findings of why I lost my job multiple times. And it's not $290,000, Your Honor. If you take the $290, and I think you said last week you're a man of math, but not, I didn't get, same as me. It's $67,000 net that she would have had if they're correct in everything they're saying. $67,000, because you take $290, divide it in half, you tax that as income, which is, say, 35%. In Massachusetts, it's probably 40, 45%. Let's use 35. And then you actually have to go to the most important part that they also, this is why I came in. They did not tell you this. They did not read from this. What the judge wrote was, on page 92, the court finds that, this is a quote, the court finds that an equitable division of the assets results in an equal division of assets, with the exception of 2 assets that post-date the parties' separation. So after the separation, there were 2 assets. The judge was very highly scrutinizing. The wife's 401k and husband's Custom Inc. stock options granted in 2014. And then I put this in bold, if any remain. Now, why would she say if any remains? Well, it's because she had another finding that she went through this, and I think, as Your Honor has asked my brother, what happened here? And she came to the conclusion that some, none, or all of the options may have remained or may have been exercised. She actually made it clear that she thought some of them may have been exercised, or all of them may have been exercised. That's why she said if any remain. She said they vested. If they vest and some might not remain, then they had to have been exercised. And she goes on to say, these 2 assets will be treated such that the spouse in whose name the asset stands will receive 65%. So she actually made a finding in here that they might have been exercised, and if they weren't, I would get 65%. So my brother didn't mention any of that in the brief or in his argument, and goes on to say things that I lived through in vivid color. I mean, I was there, and I understand why he might not have understood how they happened, but I was rigorously testifying. It was asked under cross-examination by attorneys, all kinds of things, everything, and it's very clear. They didn't have the evidence that was necessary for the judge to figure out exactly what happened. So she said, finding 89, there was no credible evidence at trial as to the value or to what extent husband has exercised some or all of the options as of the conclusion of trial. So the judge went out of her way to say he may have exercised some of these options. She just didn't know how much. And if you give them the full benefit of all that math, 290, I think it was, 65% to the husband, net of taxes at $67,000. And now, Your Honor, I think I'm finally going to answer your question. Where did it go, or what happened? It did not violate the 411, because if you go through my employment history and finding 66, 67, 68, 69, 70, 71 in my financials, you'll find that I lost my job in 2015, 2016, something like that. My $250,000 base dropped to 180. I was spending through our means. My wife was not making mortgage payments. She was held in contempt, and that's also a finding. So we were bleeding all the assets, and the $67,000, whatever the extra income was that I was getting from these options, was just being spent in the normal course, which is completely allowed under 411. Now, that's a fact question in any event, and that wasn't raised by the other parties, and that would have needed to be, because now they're asking this court, on top of the judge below who had not done it, saying that there was a 411 violation. That's not a law question, that's a fact question.
How about the transfer that was made to the children?
So the transfer that was made to the children is actually also addressed by the court and was well understood. The court, and I was testifying on this, I was asked under oath, and it said, and what the court found was in the finding that husband, myself, acknowledged transferring 18,000 shares of Custom Inc. to each of the children during the pendency of the divorce without notifying wife and in contravention of the automatic restraining order. That's interesting. In that case, the judge points out that it was in contravention of the automatic restraining order, not the other exercise of shares, though. Now, why wouldn't that matter? Well, because the judge went on to go into the deep point of there was no credible evidence that if husband had not transferred the shares, he would retain them or be able to exercise them. So what the judge felt, what she made a finding of fact, was that this wasn't part of the divorce settlement or division of assets at the end. They were with the kids, they would remain with the kids, and that didn't hurt either party because they might not have gone to anyone. That's what that says. I'll just read it again. There was no credible evidence that if husband had not transferred the shares to the children, he would retain the shares or be able to exercise them at a later point. And there's case law on that as well that says you can't pull back something into a marital estate that wasn't necessarily part of the marital estate. So the judge did hear all that, made her findings on that, and that wasn't actually, that is not before this court on appeal, just to be clear. My understanding is what he laid out was only the options for booster and not the money to the kids. So we have here a situation where major information was left out. The 65-35 intent of the judge split on post-separation, the fact that it was $67,000 in net and that was just spent in normal course, and that's a fact. The fact that I lost my job multiple times and I was reducing my income and that's where the money was going. The fact that I was under oath and I was testifying, there wasn't evidence, and this was a very prestigious law firm rigorously litigating this, and that is what Carpenter covers. That is all not in their brief. That is all in my brief, but I didn't want to let it just speak on the papers. I wanted to make sure I answer any questions on that. But I also want to get to the rest of what wasn't in there, and in the health insurance. Unless I miss anything. Okay. In the health insurance, what did they leave out? Some major things, and I had to file a supplemental appendix because they left out this material. They didn't mention, again, that I am trying, the intent of their contempt is to say I was in violation by doing something prior to the order. You can't have that as a matter of law because you can't be willfully disobedient of an order that you don't know about. How does that happen? Well, I lost my job, again, twice, between the final judgment of divorce, which came out in July of 2018. In March of 2018, I no longer had health insurance. They will say I let it lapse, or they will use wording like I did something affirmatively to let it lapse. It lapsed as a matter of COBRA lapsing. When you lose a job, you get a certain amount of time when you have insurance. The order says you must maintain, the quote, key word is maintain your health insurance. So in March, I did not know I was going to be ordered to maintain my health insurance, but I couldn't have done it anyway. What I did was nothing. I just didn't do anything. I let my health insurance go by accident. And that is not a question of fact. What they left out in their briefs is that my ex went to court, sought a temporary order, in her papers acknowledged that I didn't have insurance because I had notified her of that. And we got a temporary order before the final order that said she needed to get health insurance and get me to reimburse her. She did not do that. She got health insurance, but she wouldn't put me on it and she wouldn't seek me to reimburse her. Instead, she filed a Rule 59. Now, I made it clear she never appealed the judgment of divorce, and she never filed a 60B, but she did file a Rule 59. The Rule 59 they left out. They left it out because what she did was she said, this was a problem. Asking him to maintain his health insurance is unenforceable when he doesn't have health insurance. I need him to obtain health insurance. So she made a Rule 59 motion, which I added to the supplemental stuff, where she asks to obtain health insurance, and the judge does not put that in. So the judgment of divorce is the exact same as the amended judgment of divorce, and she just filed another contempt instead of that. Now, you might ask yourself, why didn't she just seek a modification if she knew all this? Why does she keep filing contempts? The reason is fairly simple. She got a huge promotion right after the trial. If you file a modification because you're arguing that this is part of child support, you have to do a whole financials. You have to go through the whole thing of whether you should be getting, who should be getting child support from whom, and whether health insurance should be included. She did not want to revisit that in the totality, is my guess. In fact, I would just go on to say it was only after that portion of the hearing when her prior counsel finally exited stage left and new counsel came in. But before that counsel left, she is on record, and I added this to the supplement, as saying that this was already adjudicated. In the June hearing, she admits, the prior counsel admits, quote, this was already adjudicated in July of 2018.
Counsel, I'm going to have to ask you to just wrap up.
Wrap it up? Okay, so I guess you can't be in contempt for things you didn't know were going to be rules. The findings are extremely clear. I think if you go through them, you'll find that Carpenter applies, and the mother had other avenues for redress she chose not to take, and she was very well represented throughout, and I think this is just an attempt by new counsel to relitigate the divorce, and that the totality of why we have these rules and why we have due process and why we have willful and necessary, so you avoid this 10 years of ongoing litigation.
Thank you.
Thank you.
Thank you to all the parties. The case is submitted. All right. And that brings us to a close of the sitting this morning. Thank you to all the court staff.